Now to your main matter. This is calling case number 250-55-55801. People City, Michigan versus Dante Kemp. Appearances, please.
Good morning, Your Honor. Samuel A. Ragnan, P23, 157 people. Good morning, Mr. Aisha.
And Your Honor, Mr. Ragnar, good morning as well. Vincent Hayes with and on behalf of Mr. Kemp, P76506. As to the arraignment, Your Honor, I would, of course, waive formal reading and stand my client mute.
Okay, the court will enter a not guilty plea on behalf of your client. As we've discussed briefly before we went on the record, Mr. Kemp posted a $10,000 10% bond that I'm going to continue as a condition of his release from a writ. And so that bond will be continued. While this case is pending, sir, not to possess nor use any illegal drugs. Probable cause will be February 10th. Preliminary examination will be February 19th, both in front of Judge Taylor. Is there anything else either counsel wants to put on the record?
No, Your Honor.
Nothing further, Your Honor. Thank you.
Okay.
Thank you much, all. Have a great weekend, guys.
Thank you.
You as well.
Okay.
Thank you.
Your Honor, you mentioned something about Royster.
Royster's a hospital. Yeah, you can leave, Mr. Kemp.
All right, thank you.
Royster's a hospital arraignment.
Okay, thank you, Your Honor.
Okay, Ms. Murad. Okay, you ready on Mr. Parkman?
Ready, Judge.
This is calling case number 180-584-6801, Houston, Michigan versus Damon Parkman. Appearances, please.
Samuel A. Ragnan for the people, Your Honor.
And Ragmarod, P83665 on behalf of Mr. Parkman. We waive the formal reading and stand mute.
Court order not guilty plea on behalf of Mr. Parkman. This is a 2018 case. Mr. Ragnan, your bond recommendation.
Well, people are going to ask for a $10,000 personal bond. That's 25% of the arrearage that he owes, $39,960 for failure to pay child support and medical bills. He's supposed to be paying $559 a month and he hasn't paid. But I believe the hardship here would be give him a personal bond and hopefully he'll get a job and start paying. Thank you.
Okay.
I'd ask you to adopt that recommendation. I do believe he's within the guidelines.
Yeah, I think Mr. Ragnan stated good cause on your behalf, basically. Is that correct?
I would agree.
Okay. All right, $10,000 personal bond. Your next court dates will be March 5th and March 12th in front of Judge Prentice Edwards at the new criminal justice system. Mr. Parkman, do you have any questions regarding your bond conditions and or court date? I can't hear you.
No, I don't.
Okay, have a good day.
You too, thank you.
Thank you, Your Honor.
All right, Mr. Rod, are they through on camera 3?
Let me check for you.
Your Honor, Mr. Brisky's back in the courtroom, so you know.
You turn this name in, show some taste that. See you around. Thank you so much. Thank you. Let's take it. Thanks. Understand? I want people to understand.
Flushel? Good morning. Mr. Brisky,
Yes, sir.
state your name for the record.
Stephen Brisky.
All right, this is calling case number 240-608-2701. People City, Michigan versus Stephen Brisky. Appearances, please.
Samuel A. Ragnan for the people, Your Honor.
Also on behalf of the defendant.
Oh, sorry, repeat that, counsel. I didn't catch it.
Barry Schlussel on behalf of the defendant, P41114.
You, excuse me, waive formal reading, stand mute.
Waive formal reading, stand mute, ask the plea of not guilty be entered.
Court will enter a not guilty plea on behalf of your client by recommendation from the people.
People are asking $50,000 cash surety bond. If you're able to post a bond, we're asking for a tether with home arrest. We're also asking for a alcohol tether and absolutely no driving. The defendant, even though this is back on 9/3/22, dropped his girlfriend off at the MGM casino for her to get some for winnings. He then takes off to go try to find some Xanax. He's going at a high rate of speed. He's got 3 kids in the car, Your Honor. So he driving on the shoulder of the road. He ends up going to a place to purchase some drugs, some substance in a bag. I don't even know if he knew what it was. He snorts that, gets back in the car, driving at a high rate of speed, driving on the shoulder of the road, smashes into another vehicle. Okay. So he's driving in that capacity. When he's unconscious, they have to give him Narcan to try to revive him from the accident. The kids, I believe, one was taken to the hospital. But Your Honor, extremely dangerous person on the streets. And people can say this is from the 2022, but if you're a drug addict and an alcoholic, it makes no difference when it was. It's just the act that happens. He's got 3 prior convictions, Your Honor, 12, 14, 17, and 42nd District Court from impaired, 5, 8, 17, and 39B for operating while intoxicated, and 2, 1, 17 for operating while intoxicated. So, Your Honor, second. So I believe he is an extreme danger, Your Honor. I think being released to a treatment center, I think would be the ideal situation for this defendant. Hopefully he can get his life in order. But I think he is a danger to get out because he is going to drive, I believe, again. And he certainly isn't just going to stop overnight from using drugs. When you got a drug problem, you don't just stop today. He needs help. And I think a treatment center would be the best for him. But if not, I'm asking for a $50,000 cash surety and I'm asking for a tether home arrest. Thank you.
May I respond, Your Honor?
Social?
Of course, first of all, this incident took place almost 3 years ago. My client is under treatment. He does have a disease that he's addressing. He was recently had another evaluation on Monday in Macomb County. He's doing what he needs to do. He is currently on an alcohol scram tether on a case out of Macomb County. So I don't think he needs to wear 2 tethers, that's for sure. There's been no issues. There was a couple issues in the beginning with technical glitches, but he's been on it since September, and there have been no reports of alcohol or anything else in his system, as well as what else he's been required by pretrial services. He's contacted his attorney the minute he got notice of this warrant. He presented himself in person yesterday. He came back again today. He's also on Suboxone, I believe it is Suboxone, which is, the anti-opioid drug to keep him clean. So he is taking care of what needs to be done as far as his issues. And we are in the process of getting him into the drug/alcohol sobriety court in Macomb County Circuit Court. Which is what he needs. He needs a sobriety court. I'm not going to deny he has a problem. He's not going to deny he has a problem, but we're doing everything to address it. I'd ask the court for a personal bond. He's already on a scram tether. So there's already, if he uses alcohol, it's going to be reported right away, and society is protected. He's not operating a motor vehicle. He knows he cannot.
Okay.
As far as I know,
Okay,
he's been
Mr.
since September.
Okay, Mr. Sloan, so the court's heard enough. The court haven't heard argument as to bond. Thank you for your well representation of your client. I do agree with you. He's already on a scram tether. He does not need two. And to your point, yes, I have no thought that he's going to be a flight risk. He came in person yesterday, came back this morning, so he's not a flight risk. And to your counsel's representation that he is seeking help, I'm going to give him the benefit of the doubt in this matter and give him a $50,000 personal bond. While this case is pending, sir, no alcohol, no drugs, and no driving while this case is pending. Probable cause February 7th, preliminary examination February 14th, both in front of Judge Jefferson. Mr. Brinsky, do you have any questions regarding your bond conditions and/or court date?
No, sir.
Okay, have a seat, wait in the courtroom for your paperwork.
Thank you.
Thank you, Your Honor. Have a good weekend.
Thank you. Mr. Rod. Are they still
Yes, sir.
on camera 3?
They said they can go to camera 4. Last time I checked, there was 3 left to interview still. I can go and double check now, or we can call in camera 4, or we can switch. You tell me what to do and I'll do it.
Oh no, I'll cross it when I get to it. I'll keep it up here. Okay. Are you in the building, Mr. Polk? Unmute.
I am, Judge.
I could tell. Okay.
I know
one
that
moment.
you normally do women later.
I do. That's why I was, you want to come back or log in a little later, or you want the court to give you a call when on the women's side? Unmute Mr. Polk.
Yep, I got an exam at 11. So
Okay.
if you call me, I'll take the break.
Okay. All right.
All right.
The court will give you a call when we're on the female side.
Thank you, Judge.
Okay.
Yeah.
Oh, I still get a busy signal from camera 3.
Uh-oh. You want us to switch to 4, Judge, or do you want to, let me have this switch. I got you.
Yeah,
I know exactly what you want, Judge.
Thank you.
Yes, sir.
I don't like camera 4. Camera 4 doesn't like me.
Oh, this is okay.
rock, Judge.
All right, sir at DDC, state your name, speak slowly, please.
Cortez Maurice Breakthrough.
Okay, DDC, can you bring out next Jason Tynes? All right, Mr. Breakfield, is that correct?
Mr. Breakfield, did you talk to a lawyer today, sir?
Yeah.
I'm so sorry. I just need one brief moment on Mr. Breakfield. Good evening, Mr. Breakfield, Judge.
All right, Mr. Breakfield, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give you a postal bond, and each of these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have a right to an attorney. You can't afford an attorney, one will be appointed on your behalf. The tickets are P1183473. Insurance misdemeanor, driving license suspended. Ticket P1568324, trespassing. Ticket P1588802, trespassing. Ticket P1598673, possession of drug paraphernalia, disobey lawful order of police officer. Ticket P1607301, trespassing. Ticket P1607319, possession of drug paraphernalia. Ticket P1609723, trespassing. In each of these misdemeanor tickets, sir, you were given a personal bond or dollar amount pre-trial March 7th in front of Judge Tanisha Yancey. Okay. All right, now, Mr. Breakfield, now to your main matter. This is calling case number 24044844101. You say Michigan versus Maurice Breakfield. Mr. Murad, Mr. Breakfield was given a $100 10% KPS bond set January 21st of this year by Judge Bryant. Why should I not continue that bond?
Judge, because he's homeless and displaced, and I believe he may have lost his paperwork that he received from the DDC, forgot his court date. We sent him a text reminder. I don't believe it went through. I'd ask, and there, look, there's multiple KPSs on this. I can't tell you that there's not, but I'd ultimately ask you to give him one more chance here, Judge. He does suffer from seizures, high blood pressure, diabetes. I don't believe the jail is the best place for him to be getting his care. I know that this will probably be taken care of if he just shows up. So I'd ask you to give me one more chance.
Ms. Douglas?
Your Honor, we do have some concerns about him showing up. Like counsel said, this isn't the first failure to appear. He was arraigned, it looks like, on his last failure to appear December 30th of 24. So for him to miss court again on the 14th, it does not seem like a lot of time to forget when your date is. But even if he did, the people would inquire whether he turned himself in or if he was picked up. If he turned himself in, I wouldn't object to personal.
I don't have any information that he turned himself in, unfortunately.
Okay, I think I know what I want to do on this matter regardless. Like I said, it does have a KPS history. I'm gonna give him a personal bond, but he's gonna be fitted with a GPS tether.
Judge, he doesn't have an address, unfortunately.
Well, I know there's some homeless shelters that you can tether to.
Okay, can we do that?
And I'm sorry?
Can we do that in the order? Can we put a GPS tether to a homeless
Well,
shelter?
well, like I said, I'm not gonna put any homeless shelter. That's up to him, address, homeless shelter, whatever. I'm not gonna narrow it down to just a shelter. He can stay wherever, just so long as he finds a place that he can tether to.
Judge, and I'm so sorry. I know you hate when the record lasts this long on these types of cases, but it's just been my experience that when we don't provide either a specific shelter or put it in the actual order for the county to transport him to that shelter, that he's ultimately just going to be waiting there because he's not able to provide an address for the GPS tether agency.
Well, let me tell you, I've got burnt on this before because I gave a specific GPS tether to a specific place. I think one instance they were full, and another instance they didn't take men. It was a women's shelter. So I've learned to put GPS tether and just keep it blank so it won't narrow down his options. And I want to come back and revise the order.
Would the court be more inclined to just continue the $100 10% instead of that? I just know he's got a better chance of not staying in the jail the whole time, I think, with that.
Okay, I'll continue it.
Thank you, Your Honor.
$100 10% capious bond. Okay, give me one moment.
Thank you, Your Honor.
Okay, $100 cash 10%. Bond redetermination, Monday, February 3rd, 9 a.m. in front of Chief Judge McConicle. Pre-trial, February 11th, in front of Judge Bryant. Step aside, sir. Can we bring out Jason Tynes next?
Thank you, Your Honor.
Okay.
Is this retained, Your Honor?
Yes, Your Honor.
Okay. Okay, are you Mr. Tynes?
Yes, sir.
Okay. State your full name for the record, please.
Jason Daniel Time.
Okay, give me one moment. Ms. Marad?
Yes, Your Honor.
Does anybody need to interview Mr. Royster?
No, Mr. Royster's ready to go.
Okay. Okay. All right, Mr. Tynes, this is case number 250-5524701, Peace of Michigan versus Jason Tynes. Appearances, please.
Jennifer Douglas for the people, P72748.
Good morning, Your Honor. May it please the court, Lowell Friedman, P56185, on behalf of defendant Jason Hines.
Okay, Mr. Freeman, waive formal reading, stand mute.
Waive the formal reading, stand mute, Your Honor. Thank you.
All right, the court will enter not guilty plea on behalf of your client. Bond recommendation from the people.
Your Honor, Mr. Tynes, the people wouldn't object to a 5,000 cash or surety. We'd ask for no contact. I do recognize that this dates back to 2023, 2 years ago, but Your Honor, or not quite 2 years ago, because it's October 23. But Your Honor, given what's alleged here, given multiple firearms were found in the home, we do have some safety concerns. If this was more recent, I'd be asking for a higher amount. But given what's alleged, given the time has passed, I'm asking for 5,000 cash or surety and no contact. As far as priors go, I just see that there were some traffic priors. I don't have information about other priors, but that's what the people are asking for.
Mr. Freeman, response?
Sure, thank you, Judge. This case has obviously it's dating back some time. It only came to my client's attention, and I want to be very transparent with the court, with prosecution. I'm representing Jason on a matter out of the 46th District Court in Southfield. Allegations that went back 7 years ago, where he was just charged on Monday with CSC. It's a child who was 7, who's now 14, who lives out of state. I'm just getting my hands on discovery. It makes no sense. On that case, the court placed a $100,000 cash surety bond, and he was taken into Oakland County Jail. Bond was posted through a surety 2 days ago. As required, a GPS tether was placed on his ankle, and only during the arraignment did we learn of these charges. He was brought over to Detroit yesterday. Here we are. I understand the request for the 5,000 cash surety. Judge, I can tell you the family struggled to come up with the money to post the bond through the bondsman. He will be released upon being released with a GPS tether. I don't know what these allegations are even about, but I suspect they have something to do with the mother of the child from the CSC that goes back 7 years ago, which just smells funny to me. Given the fact that he's on bond on that case, we have a PCC on February 5th. I'd ask for a personal bond. He's not going anywhere. He lives here in metropolitan Detroit. He has a 2-month-old daughter that he lives with. He has his own 14-year-old son that he lives with. He's employed. He really has no other issues other than a 7411 on a possession of marijuana case from 2009. So these two scenarios, which date back, are not a part of who he is, and we're going to be fighting everything here once we get our hands on the report. So I'd ask for a personal bond. The family has no more money to post.
Okay. Court haven't heard argument as to bond. The court's concern is basically tracking him and making sure the parties stay apart. I'm going to give him $100,000 personal bond.
Thank you.
He's already been fitted with a tether, so there's no need for 2 tethers.
Thank you.
No contact with the complaining witness, Jennifer Hallman. You cannot go back to the warmer address. While his case is pending, you cannot possess or purchase any handguns, firearms, other dangerous weapons. Is that clear, Mr. Tynes?
Yes, sir.
All right. Probable cause, February 7th. Plenary examination, February 14th in front of Judge Giles. Is there anything else either counsel wants to put on the record?
Just so defense counsel knows, it does look like the complaining witness in this reported this the very same day that she said it happened, and it looks like it's just been with the prosecutor's office for a long time. So just as far as the timing, just so you understand.
I appreciate that. Thank you. And just so the record's clear, that is the mother of the child that goes back where we'll sort this out. But thank you for that. I appreciate knowing that and why the delay. And we didn't have an answer when we were in Southfield as to why he had this open warrant. So now we understand why. But he'll have no contact with her. I'm not even sure she's local, but it doesn't matter. He'll have no contact with her and have the GPS tether, which she's already wearing.
Okay. Thank you, counsel. Have a good day.
Thank you, everybody. Have a great day.
You too.
Okay.
Thank you.
All right. Are we ready on William Royster?
Ready.
Mr. Royster, unmute. Turn on your camera.
Hey, good morning, Judge.
Hi, Officer McCree. How are you?
Okay,
Okay, it's my understanding he does not need to speak to the attorney, so we can proceed with the waiver.
you can.
Mr. Royster, yes. Mr. Royster, state your name for the record.
Yes, I can't hardly hear
Can you, McCree, can
Yes.
you either move him closer to the phone or move the phone closer to him?
Okay, what's that?
Okay, sir, state your name for the record.
Yeah, William Dion Royce.
Okay, this is calling case number 130-586-3601. Peace and Michigan versus William Dion Royster. Appearances, please.
And Samuel A. Ragnan for the people, Your Honor.
And Ride Murad, P83665, on behalf of Mr. Royster, we waive the reading and stand mute. He's been advised of his rights.
All right, the court will enter not guilty plea on behalf of Mr. Royster. This case stems from nearly 12 years ago. What is your bond recommendation, Mr. Ragnar?
We're asking for a $10,000 personal bond, Your Honor.
That's fair. I'd ask you to adopt it, Judge.
$10,000 personal bond. I'm sorry, Mr. Murad.
Nothing, Judge. I apologize.
$10,000 personal bond, Mr. Royster.
$10,000.
Nope, you don't got to pay anything to get out, sir. You're all good.
$10,000 personal bond. You don't have to pay anything.
Oh, I'm sorry.
These. I know. I understand, sir. You got trouble hearing.
Yeah.
Via Zoom or whatever. So you don't have to apologize for anything. While this case is pending, sir, you're not to possess any handguns, firearms, other dangerous weapons. No contact with Peggy Tony. You cannot go back to the Strathmore address where this incident allegedly occurred. Like I said, Mr. Royster, you don't have to apologize. You're in the hospital, and we're having some problems with Zoom connections and hearing. So, did you understand everything I just stated, sir?
Sorry.
Is that a yes?
Yes.
Okay. Here are your court dates, sir. Pre-trial, February 11th, in front of Judge Garrett. Do you have any questions regarding bond conditions and/or court dates, sir?
Let me see. February 11th. Okay. I guess that's fine. It's fine.
Well, it better be fine, but you can log on Zoom if you can't make it.
We'll reach out to you, Mr. Royster. We got your information.
You guess it's fine.
Yeah.
All right. If you got a conflict with that date, I have you or your attorney contact Judge Garrett's courtroom to get a change of the date, okay?
We'll take care of it, Judge.
Okay. Sounds like you're a busy man. Have a good day, Mr. Royster.
Okay, you as well.
All right. Thank you.
All right.
Thank you, Your Honor.
Thank you, McCree. All right. DDC, who's next? Any day now. What is your name?
My name is Donaldo Chinchilla.
Okay, how are you, sir?
Well, doing decent, in a bad situation.
Okay, I just asked how you're doing. All right, Mr. Chinchilla, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, your personal bond, and each of these misdemeanor matters that carries a maximum penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. You can't afford an attorney. One will be appointed on your behalf. The ticket in question is P1217165, driving license suspended. Pre-trial on this ticket to be March 6th in front of Judge Kennedy. Now to your main matter, sir. This is calling case number 2504432-301. Peace and Michigan versus Donaldo Chinchilla. Appearances, please.
Jennifer Douglas for the people, P72748.
And Ride Murad, P83665, on behalf of Mr. Chinchilla. We waive the formal reading and stand mute. He's been advised of his rights.
Court, we're in a not guilty plea on behalf of Mr. Chinchilla. Mr. Murad, I want to start off with you. I read the report earlier this morning, and what gives this court a problem with your client is not only the allegations with respect to this complaining witness, but per lien in the report that he has prior mental orders, as well as a current PPO, or personal protection order system, that was served on him December 28th of last year on a different complainant. Now, couple is the allegations in and of itself with this current complaint witness is bad enough, but coupled with that, why should not give your client a cash bond? It appears to be, from this record, from what I've seen in the investigative report, a danger to the community, particularly to women, allegedly.
So thank you, Your Honor. First, he has no criminal history that I'm aware of besides traffic. He has a job interview at Domino's today. He lives with his mother. I can't speak to the other expired PPO, but what I can tell you about this case is that there are no
expired. It was not expired. It was served on him last month.
Oh, I apologize. I thought you said last year. So what I can tell you is about this case, there's no injuries. There's no presence of threat whatsoever. There's nothing that tells us he was ever a harm or tried to harm anybody whatsoever. He understands after our conversations have absolutely no contact with both the restaurant, that apartment unit. We had a long talk about that. I do believe he understands. I think the allegation is some boundaries were crossed. And after our conversation with him and his lack of criminal history, his lack of KPS history, I don't see a problem here with a personal bond. You can even go a step further and do a tether. I mean, it's going to cause him to miss his interview, but that's a great way to keep these parties apart while still affording him his liberties. So if you're inclined, I'd ask for personal tether, but really I do believe personal bond and no contact would be appropriate here. Again, no felony convictions, no misdemeanor convictions that I'm aware of either.
Ms. Douglas?
Yes. So, Mr. Murad, I sent you an email because I just finished prepping this while the case is being called. So I do have some concerns for safety. Just focusing on what's in the investigator's report right now, Your Honor, I would note that while Mr. Chinchilla appears to have been arrested at his mom's house, he told police that he was homeless and slept in his car, and that's why this complaining witness keeps seeing him outside her home. And so it's a little confusing. He's nodding. I notice he's nodding. So, Your Honor, it would be concerning to the people about how he's going to keep a tether charged if he doesn't really live at his mother's house. If he just lets the tether charge go down, he'd be gone. There'd be no way to track him. We would note that this does not seem to just be a mere violation of boundaries. That would be like asking somebody out 3 times and they've already told you no twice. Your Honor, this is a situation where this man is a stranger to this complaining witness. He's been at her home at least 3 times. The time when he opens the door, the time when he leaves the note, and the time when he comes back and knocks. So he's been to her home at least 3 times, not to count the times that she's seen him outside her home. He's come to her work multiple times. And in the email that I sent Mr. Murad, that other PPO appears to be the protected person appears to be the owner of this restaurant, because the owner of this restaurant has complained of being stalked by Mr. Chinchilla. And
all
so
that's duly noted, Ms. Douglas. But as I indicated earlier, I'm inclined to give a cash bond. Are you in agreement with that, or you just want to tether?
Your Honor, I wanted both because I don't know what resources his mother might have. If he gets out, then there's no reason to think he isn't going back.
May I respond, or are you ready to roll?
Briefly, Mr. Murad.
I mean, he was arrested at his mother's place. Whatever hearsay allegation he told the police isn't necessarily relevant. He's clothed. He gave us the address. He has a job interview. Again, I don't see him not charging his GPS tether. If there was a felony history, I would be a lot harder to argue against the cash bond, but it's a misdemeanor case, Judge. Nothing assaultive or violent happened. I don't see a reason why you can't just give him a GPS tether, let him work only.
And Your Honor, in the email I sent Mr. Murad,
Douglas, I'm ready to rule. I'm going to give him a cash bond with a GPS tether. I find, like I said, and I rarely give cash bonds for misdemeanors, but this is clearly an exception in this matter. the degree of contacts he's had, and then, like I said, coupled with the fact that last month he was served with a PPO for another complainant, I find that he is a danger to the community. And so notwithstanding his job interview, I understand, people need to work or whatever. But given these allegations in the report, I do find he is a threat. And I will say this, I'll add this for the record. The other thing I noticed is that particularly for the complaining witness in this matter, it's particularly troublesome to her because if I recall correctly, she stated she's in fear of being attacked, killed, even kidnapped due to a past incident that occurred when she lived in Mexico, where she was kidnapped for approximately 22 days. And so, given her state of mind, this woman is living in fear of this gentleman. In addition, coupled with the statements from Miss Douglas in terms of his unannounced arrivals or visits, or however you want to describe them, to her home. So I'm going to give him a $50,000 cash surety bond for those reasons. GPS tether, 9 p.m. to 6 a.m. curfew, if he's able to post bond.
Consider 10%, Judge.
You can do that on Monday.
Thank you, Your Honor.
Bond redetermination be Monday, February 3rd, 9 a.m. in front of Chief Judge McConicle. Pretrial February 11th in front of Judge Bryant. And to note, Mr. Rod, I duly noted in terms of that this is just a misdemeanor, but the degree and the frequency of his actions are very, very troubling. I find the court finds very, very troublesome. Also, he's not possessing handguns, firearms, other dangerous weapons. No contact with Jaris Cortez, and he cannot go back to the Ellesmere address. Again, bond redetermination Monday, February 3rd, 9 a.m. in front of Chief Judge McConicle. February 11th, pretrial in front of Judge Bryant. Step aside, please. Speak slowly.
How you doing? This is Mrs. Baffert.
State your name slowly, please.
Demetrius Baffert.
Demetrius Banford? Is that correct?
Yes, sir.
All right, Mr. Banford. You have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. If you can't afford an attorney, one will be appointed on your behalf. The tickets are P163-74442. Refusing to leave active commercial establishment after being requested by the owner. Ticket P165-6236. Trespassing. Ticket P165-6268. Possession of drug paraphernalia. And finally, U558-71820. Entering a vacant building without owner's written permission. In each of these misdemeanor, just listen, sir, just listen. In each of these misdemeanor matters, so you're getting a personal bond or dollar amount. Pre-trial, March 10th, in front of Judge Yancey for these tickets. Now, sir, to your two main matters. Case number 230-453-4801, People State of Michigan versus Demetrius Banford. And case number 240-458-9201, People State of Michigan versus Demetrius Branford. They're both retail fraud third-degree cases with capious status, one at arraignment, one at pretrial. Appearances, please.
Jennifer Douglas for the people, P72748.
And Red Murad, P83665. On behalf of Mr. Banford, we waive the reading stand mute. He's been advised of his rights.
Okay, the court will continue a not guilty plea on behalf of Mr. Banford. Mr. Murad, why should I not continue the capious bond set by Judge Bryan in both of these matters?
Judge, on the 23 case, I think there's only been one capious. On the 24 case, I believe there's only been one capious as well. If I'm not mistaken, I would ask the court to give him one more chance here on both of these matters. I don't have a good reason for him missing court. I really don't. I'm unaware of any open matters that are pending against him, any felonies, any probation or parole. For all those reasons, I'm asking for an opportunity here to give him a shot. I know these bonds are only $10, but unfortunately, he just can't post them. For those reasons, he's not employed either. So I'd ask you to give him a shot here, Judge.
But just for clarification, Mr. Murad, the 23 case, I see $1,000 10%, and on the 24 case, it's $100 10%. Just so the record's clear.
You're correct. I apologize.
Okay, no problem, no problem. We all make mistakes. Ms. Douglas, your response?
Your Honor, on the one that's capious on arraignment, I wouldn't object to a personal bond. On the other one, I lead up to discretion of the court, but it does appear that he had multiple failures to appear, Your Honor. And so I would just say if he turned himself in on that case, then I have no objection to personal.
I don't believe he turned himself in, Your Honor.
Is he employed, Mr.?
He's not working, Judge. I think there might be some underlying issues that we haven't had the real chance to explore with him just yet, but I'm hopeful that we will. Again, the only thing I'll leave you with is,
Mr. Murad, if I gave him a personal bond with a tether, would that pose a problem?
he gave us a good address, but I would still ask you to consider not doing that, Judge.
You want me to continue the capious bonds?
No, I want you to make them personal. Give him a chance here, Judge. There's a presumption against even probation with these types of cases, you know.
Well, I mean, he's had two chances from February 2024 to October. And if he's not working, I don't know why he's not keeping track of his court dates.
Judge, my law partner just advised me that when he was arraigned on the most recent matter, the case that was in current status was never called. If that makes a difference for you.
Well, it looks like he was scheduled for arraignment in front of Judge Bryant. So, and that was, anyway, I'm not going to go back and forth on this. I am going to give him a personal bond with a GPS tether on both matters.
Thank you, Your Honor.
$1,000 personal bond, GPS tether on the most recent case. I'm not going to put two tethers on him. Pre-trial February 11th in front of Judge Jones on both of these matters. No contact with Family Dollar, no contact with Dollar General. Step aside, sir.
Thank you.
Sir, speak slowly.
Say it. Alderman G. R.O.E. Tarrant, Tarrant.
Thank you, sir.
Thank you.
This is case number 25055-54201. Peterson, Michigan versus Deron Tarrant. Appearances, please.
And Samuel A. Ragnan for the people, Your Honor.
And Rad Marad, P83665 on Mr. Tarrant, who waives the formal reading, stands mute, and would love a personal bond, Your Honor.
Okay, the court rendered a not guilty plea on behalf of Mr. Tarrant. Given the nature of the offense, ties community, lack of criminal history, and objection to a personal bond.
Well, people are gonna ask for a $35,000 personal bond.
No objection.
All right, $35,000 personal bond, Mr. Tarrant. While this case is pending, you're not to possess any handguns, firearms, other dangerous weapons. Probable cause, February 7th in front of Judge Robbins. Criminal examination, February 14th in front of Judge Giles. Step aside, sir.
Thank you, Your Honor.
Mr. Ross, you spoken with Mr. Chase?
I'm ready, Judge.
We're ready, Judge.
Okay, Mr. Chase, step up, please. Good morning.
Morn.
State your name for the record, Mr. Chase.
Brad Chase.
Sorry?
Brad Chase.
Okay, thank you. This is case number 240606501. People City, Michigan versus Brad Chase. Appearances, please.
Jennifer Douglas for the people, P72748.
And good morning, Your Honor. Sydney Rushing, P78830, appearing on behalf of Mr. Chase, who appears to my left. Mr. Chase has been advised of his constitutional rights, waives formal reading, stands mute, and that a not guilty plea be entered on his behalf.
The court rendered a not guilty plea on behalf of Mr. Chase. By recommendation from the people, noticing that this is a 2-year-old case.
Indeed, Your Honor, given the age of the case, the people wouldn't object to a $75,000 personal bond. I am asking for no alcohol during the pendency of the case and no driving without a valid license. Your Honor, here we have a 3-car crash on the freeway, which could have resulted in someone being seriously injured. Fortunately, that does not appear to have happened. But the blood draw happened at 3:20 a.m. This response to the incident was about 1:10. So 2 hours later, Mr. Chase's blood alcohol was 0.183, which is pretty high for 2 hours to have passed. But given the age of the case, I'm asking for that higher personal bond and the condition of no alcohol and no driving without a valid license.
Ms. Rushing?
Your Honor, no objection to the personal bond.
$75,000 personal bond, Mr. Chase. While this case is pending, you're not to drink any alcohol, no driving unless you have a valid driver's license. Pre-trial, February 11th, in front of Judge Jones. Have a seat, wait for your paperwork, sir.
Thank you so much, Your Honor.
Okay. I need your full name for me.
State your name slowly, sir.
Joseph Thomas.
This is case number 16045234001. Peterson and Michigan versus Joseph Thomas. Appearances, please.
Family Ragland for the people, Your Honor.
And Ryan Marat, on behalf of Mr. Thomas, we waive the reading, stand mute. He's been advised of his rights.
Court will not guilty plea on behalf of Mr. Thomas. Bond recommendation from the people, given that this is nearly a 9-year-old case.
People are asking for $1,000 personal bond.
No objection.
No contact.
No objection.
$1,000 personal bond, Mr. Thomas.
Thank you.
$1,000 personal bond, Mr. Thomas. While this case is pending, you don't have to have any contact with the complaining witness, Simi Jordan. Pretrial, February 11th, in front of Judge Jones. Step aside, sir.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
Yes, sir, Your Honor. I just told somebody from say, that's what it is. I said, Your Honor, this got first. Yeah, when they called and said, they.
Okay, good morning, sir. State your name slowly for the record, please.
Jason Clark.
It wasn't that, didn't that case go to Judge Robbins?
Yes.
Right. Okay. You don't have any traffic matters, so so long as you've been in front of Judge Robbins this morning, you're fine, sir.
Yes.
Okay, you can step aside.
All right.
What was that?
Hold on one moment. Yes, Mr. I'm sorry. Yes, Mr. Ragnar, what's your question?
What was that defendant's name, please?
Jason Clark. He went to Judge Robbins early this morning.
Clark, okay. Thank you, Your Honor.
Okay. Sir, state your name slowly, please. Jonathan Arnold? Okay. This is case number 25055444501. Peterson, Michigan versus Jonathan Arnold. Appearances, please.
Family Ragland for the people, Your Honor.
Brian Marat, P83665, on behalf of Mr. Arnold, we waive the formal reading. Mr. Arnold stands mute. He's been advised of his rights.
Court will not guilty plea. Mr. Arnold, your attorney waived the formal reading of the complaint and warrant. wants me to enter a not guilty plea on your behalf, which I will do. Court will enter a not guilty plea on behalf of you, Mr. Arnold. You presume innocent in this matter. So I want the record to be clear. Bond recommendation from the people.
People are asking for a $50,000 personal bond, Your Honor. This defendant allegedly sold a stolen vehicle to the complaining witness for $5,200 with a forged title. He went to the Secretary of State, told him it was forged, vehicle was stolen, and so we're asking for the $50,000 personal bond. He has a prior, Your Honor, on 4/24/23 for CCW for on PIDA. I'm not sure if he's still on probation or not. That's all he has.
I wouldn't object to the personal bond, Judge.
All right, Mr. Arnold, the court's probable cause to be February 7th. Both in front of Judge Giles. Step aside, sir.
Thank you, Your Honor.
Thank you, Your Honor.
Good morning, sir. State your name, please.
Gregory Johnson Curtis.
This is case number 240-602-0201. Gregory Johnson Curse. Appearances, please.
Ryan Murad, P83665, on behalf of Mr. Johnson Curse. We waive the formal reading. Mr. Jonathan Curse stands mute. Johnson Curse stands mute. He's been advised of his rights.
Mr. Ragnar, appearance, please, unmute.
Sorry, Your Honor. Samuel A. Ragnan for the people.
The court will not guilty plea on behalf of Mr. Gregory Johnson Curse. Bond recommendation from the people.
Well, yeah, the people are asking for a $50,000 personal bond with a tether with a curfew. The defendant was walking down the street. The police thought they observed a gun. He told the police it was a facsimile, and with that, he takes off running. He ends up pulling the gun out, holding it in his hand, and he's taken to the ground by the police and arrested. So I believe that he is a flight risk and maybe not show up. So I think that he should have a tether, Your Honor. Thank you.
Does he have a history of Sacabius?
No, he doesn't.
Okay, Mr. Murad, just address the issue of tether, please.
No criminal history. He's got a stable residence, so he's not going anywhere. He's been in Michigan his whole life, taking care of his two kids. Stable address here in the city of Detroit. I think this is his first case ever. For all those reasons, I don't see a necessity for the tether charge.
I agree with you, Mr. Murad. $50,000 personal bond. While this case is pending, you're not to possess any handguns, firearms, other dangerous weapons. Probable cause February 7th, preliminary examination February 13th, both in front of Judge Jefferson. Step aside, please.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
You got a personal, man. You're getting out. You don't have to say anything. You're all set.
Have a nice day. Have a nice day, Ron. Yo, how much personal bond?
$50,000 personal bond. 50. Good morning, sir. State your name slowly.
Tommy Jones.
Tommy Jones? Is that correct, sir, for the record? Is that correct? Tommy Jones?
Yes.
Okay. Thank you. It's calling case number 250-555-8101. Pearson, Michigan versus Tommy Jones. Appearances, please.
Samuel A. Ragnan for the people, Your Honor.
Ryan Murad, P83665, on behalf of Mr. Jones. We waive reading, stand mute. Mr. Jones has been advised of his rights.
All right, the court is not guilty plea about Mr. Jones. Mr. Polk, we're getting close to the female side. You logged in right on time. All right. Again, court will enter a not guilty plea on behalf of Mr. Tommy Jones. Bond recommendation from the people.
People are asking for a $10,000 cash surety bond. To be able to post a bond, we're asking for a tether with home arrest, Your Honor. This is a situation where
I know a vehicle is a vehicle issue.
Well,
and
Teresa,
okay, let me ask you this then. You're asking for a cash bond. Does he have a criminal history?
well, he's got 10 cases that were filed today in district court on 1/31/2025 filed here for this 2 counts of forgery, 2 counts of uttering and publishing, 2 counts of motor vehicle, 2 counts of false pretenses, and 2 counts of stolen property. So that's going to be up probably tomorrow. So that's the reason for the cash bond. Thank you.
Okay, well, we'll deal with those cash bonds for those cases. Let's stick to the facts at hand on
All
this
right,
case.
well, then I have no objection to $50,000 personal bond with a tether.
Okay.
Thank you.
All right, Mr. Rod, please just issue a tether.
Judge, no capious history, no underlying criminal history. He was arrested here locally, walking down the street in the city of Detroit. No violent issues, no tendencies to keep these parties away besides a no contact order. I think an ordinary personal bond with your ordinary conditions should suffice and be most appropriate.
Now, Mr. Radnor, just for clarification, how many cases you said were coming down the pipeline?
10. I'm looking at them right now.
And they're all for fraud or false pretenses related cases?
Yes.
Is there a case number?
There is.
Which one?
I'm sorry. I don't have a case.
Okay, hold on. Have they been signed by the prosecutor's office?
Well, I assume so because it says they've been filed with the
No,
district
we don't
court.
do assumptions here. Have they been signed or they're under review? That's 2 different things.
Well, they wouldn't be filed in the court, would they, if they were signed? Isn't that true?
I'm trying to clarify what you said, Mr. Ragnar.
I'm looking. Thank you. Okay, my fault. I should have.
Okay. Nonetheless, $50,000 personal bond, no GPS tether.
Okay.
Probable
Thank you,
cause
Your Honor.
February 11th. Preliminary examination February 18th. Both in front of Judge Giles. Step aside, Mr. Jones.
Thank you, Your Honor.
All right, good morning, sir. State your name slowly, please.
Reginald Wells.
All right, Mr. Wells, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. If you can't afford an attorney, one will be appointed on your behalf. The tickets are P1066947, driver license suspended, no insurance misdemeanor. Ticket P1494537, open alcohol and motor vehicle passenger. Ticket P975461, driver license not valid. Ticket U59314221. Disorderly conduct. Ticket U59314321. Disorderly conduct. Ticket U598335521. Disorderly conduct. Ticket U5984421. Urinating in public. In each of these misdemeanor matters, sir, you're given a personal bond, no dollar amount, pretrial, March 10th in front of Judge King. All right, now to your main matter, sir. This is case number 214528501. People said Michigan versus Reginald Wells. Appearances, please.
Jennifer Douglas for the people, P72748.
Ryan Moran, P83665. I'm here for Mr. Reginald Wells. We waive the formal reading. Mr. Wells stands mute. He's been advised of his rights.
Court will continue not guilty plea on behalf of Mr. Wells. Mr. Rod, why should I not continue the $500 10% KBS bond set December 9th, 2021 for Mr. Wells.
Judge, there was a period of time that Mr. Wells was incarcerated on another matter in the Wayne County Jail. I've been unable to determine whether or not there's an overlap, but I can tell you that his contact information did in fact change. We now have 2 numbers for him, a good address. We've explained the situation to him. He's now a supervisor licensed through the state. He's earned a certified trade as an asbestos specialist. I know the report has some troubling allegations, but I would ask the court to give Mr. Wells a final opportunity to come into court and to come into compliance.
Ms. Douglas, response?
Your Honor, my response would be that these are serious allegations, that it has been some time since he's been missing, and I don't know when he may have been incarcerated, but if there's a large gap in time between when he was finally not incarcerated and this time, we would ask you to keep the bond.
Okay, court having heard the argument as to bond, I'm going to give him the benefit of the doubt in this matter. Give him a $500 personal bond. I also note for the record that this was during COVID as well. And I'm not sure if that's had any factor with respect to communication with respect to court dates, times, et cetera, et cetera. So I want to give him the benefit of the doubt for those reasons. Give him a $500 personal bond. Pretrial February 11th in front of Judge Jones. Step aside, sir.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
How you doing?
Good morning. State your name slowly for the record, please.
My name is Jaden Cross.
Okay. All right, Mr. Cross, this is case number 250-5558-301. Peterson, Michigan versus Jaden Cross. Appearances, please.
Family Ragnan for the people, Your Honor.
Ryan Murad, P83665 on behalf of Mr. Jaden Cross. Waive the reading, stand mute. Mr. Cross has been advised of his rights.
Court will enter a not guilty plea on behalf of Mr. Cross. Bond recommendation from the people.
And the people are asking for a remand in this matter, a very serious matter. The man goes into the gas station store to buy something.
Jaden Cross, this is carrying a concealed weapon. You want a remand?
Say nothing, Mr. Cross. Don't say nothing.
Excuse me. I thought well, I had it as an armed robbery. My apologies. Thank you for clearing that up, Your Honor.
No problem.
You have the same date, Your Honor?
5/14. Number 2. You mean the date of offense?
Yes.
The date of offense is January 29, 2025. This is case number 250-555-58301. Jaden Cross, charged with carrying a concealed weapon.
Well, in that case, I would ask for a $25,000 personal bond, but I'm looking at a case for an armed robbery, but that's something that's back in May.
Same person?
Yes, same person, age 19, but I don't know the status of it. I just found this case.
Okay. Mr. Rod?
Briefly, I just ran his name in the ROA. I don't see any other charges, felonies besides this. I'm asking for a straight personal here, and I think it's a pretty illegal search. The inventory, the inventory.
But we're not here for that. We're not here for that. $5,000 personal bond. Now, why you're not to possess any handguns, firearms, other dangerous weapons. You can make your legal argument at preliminary examination. Probable cause February 7th in front of Judge Kevin Robbins. Preliminary examination February 12th in front of Judge Giles. Step aside, sir.
Thank you.
Murad, I did change it to 25,000 per month.
I thank you, Mr. Ragnar.
I wouldn't. That is a little shocking. Thank you.
It was for me too.
Same.
Yeah, I was ready on that.
Any more males, or that should be it?
Female.
Hold on, DDC, do you have Sebastian Counts?
Sebastian Counts, they took him off and said he's not going.
No, is Sebastian Counts there? I have to rein him on some traffic matters.
Is
he there?
We'll get him because we didn't pull him, so.
I'm sorry?
We didn't pull him because they took him off. Get him.
Okay. Okay. All right, can we go on the female side? I'm sorry? Yeah.
Mr. Pope, who do you have?
He's got Diamond Martin Travis.
Have a seat in your chair, state your name. State your name.
Diamond Martin Travis.
Okay. Ms. Travis, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give a personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. You can't afford an attorney, one will be appointed on your behalf. The ticket is P1420775. Leaving the scene of a personal injury accident. Driver license not valid and no insurance misdemeanor. Pretrial March 7th for these misdemeanor matters in front of Judge Michael Wagner. And now for your main matter. This is case number 250-554-2902. City, Michigan versus Diamond Martin Travis.
Yeah, she said I was hired, or she said this happened.
Jennifer Douglas for the people, P72748.
Your Honor, may it please this honorable court, Larry Pope on behalf of Diamond Travis Martin, who is present by way of Zoom. My P number is 48164. Travis Martin, would you state your name for the record?
Diamond Martin Travis.
Okay. All right. Good morning. The court will enter not guilty on behalf of your client. Bond recommendation from the people.
Your Honor, this is a reissue. This originally was issued, looks like last year, and then she was given a bond that was reduced to 100,000, 10% cash or surety with tether at redetermination. Your Honor, here we do have safety concerns. The case was dismissed at exam because the complaining witness failed to appear. As an investigator's report reflects, the complaining witness said he had car trouble, but here we have an alleged attempt to murder somebody. Your Honor, there is a pending case that Ms. Martin Travis has. It is at Circuit Court 24-003398-01. That has the same date of offense, but a different complaining witness. I think it's this complaining witness's mother. Your Honor, that's a home invasion first. Trial is scheduled for for March. So we do have concerns for safety here. I'm going to ask for that bond that was in place to be reinstated, the 100,000, 10% cash or surety with tether.
Ms. Douglas, just a follow-up question. I read the investigator's report, and she's basically charged as an aider and abetter. Is that correct?
Yes, Your Honor, being the driver while the boyfriend shot out the car.
Okay. Mr. Pope, your response?
Judge, I'm asking for a personal bond. My client initially, she paid the bond that was on the case before it was reissued. It was a substantial bond. I believe the payment was $10,000. It was 10% of $100,000. She did not leave the jurisdiction. She's been here. She's been at every court case that she needed to be. She is a mother of 3. The complaining witness is her soon-to-be ex-husband. And we absolutely have some things that we think are not going to hold up when this case finally gets before the courts. So I'm asking the court to provide her with a personal bond. She's not a flight risk, and she's not a danger to the community. Again, this is based upon my belief that, as the court has already outlined, they think that she's an aider and abettor, and of course, they need to be able to prove it. And she has retained counsel, and she'll be at each and every hearing that she needs to be at.
Okay. All right. Thank you, Mr. Polk. In light of the fact that, to my view, my way of thinking, she's not the primary suspect charged as aider and abettor, and coupled with the fact that this case is a reissue, there's some little doubt as to whether this case may go forward or not. I don't know. It seems like domestically related. I'm going to give her a $100,000 personal bond in this matter. While this case is pending, ma'am, you're not to possess any handguns, firearms, or other dangerous weapons. No contact with the complaining witness, DeShante Smith. Probable cause February 7th, preliminary examination February 13th. Both in front of Judge Jack Hay. Step aside, please, ma'am.
Thank you very much, Your Honor.
Thank you. All right. Are you Sebastian Counselor?
Yes, sir.
State your name for the record, please.
Sebastian Counts.
Mr. Counts, you have some traffic matters which you failed to appear in court for. As a result of your failure to appear, warrants for arrest were issued. The court's going to set aside this arrest warrant. You approach the bond in this misdemeanor matter that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have a right to an attorney. Can afford an attorney. One will be appointed on behalf. The ticket is U594-44621. Possession of a glass pipe, drug paraphernalia. Pretrial will be February. Strike that. March 6th in front of Judge Kennedy. You can step aside, sir. Ms. Johnson, do you have Ms. Ellison's case? You give back to me. The only thing I have is this one. Ms. Ellison, Lorena Ellison. What's your name, ma'am? State your name slowly.
Arbania Griffin.
This is case number 250. 250-555-7501. People say Michigan versus Albania Griffin. Appearances, please.
Samuel A. Ragnan for the people, Your Honor.
You all right, Mr. Rod?
Sorry, Judge, I didn't know I was muted. Rag Marat, P83665 on behalf of Ms. Griffin. We waive the reading, stand mute. She's been advised of her rights.
Court order not guilty plea on behalf of Ms. Griffin. Bond recommendation from the people.
People are asking for $150,000 cash surety. She's able to post the bond. We're asking for tether home arrest. Your Honor, I will be quick. Her and a male were escorted out of a nightclub along with 3 other people outside. They alleged that they picked a fight with the other people. Her boyfriend, or the man she was with, ended up unconscious on the ground. He pulled out a gun and started shooting at the 3 people. The security guard went and got his rifle out of the car, came back, told her to put the gun down, which he put it back in a pink purse, dropped the purse, kicked it away, and then fled. It's alleged in this report that she fired on 2 different occasions, second volley. But Your Honor, subsequently, the man that was shot in the buttocks obviously had to be treated at the hospital. There's witnesses that identify her specifically, the other people as well. Plus, there's DNA evidence on the gun and on the lower part of the gun and on the handle of this defendant. That was the gun that was in the pink bag that he used to shoot. So very serious matter. shooting at people. Luckily, she's not a better shot because it would have been a worse situation. But we have a man that shot in the buttocks by this defendant, allegedly. So we think she's in extreme danger. And we'd like to make sure she has a high cash bond and a tether home arrest. Thank you.
Well, I'm sorry, Mr. Ragnar, what was the dollar amount you saw?
$150,000 cash. Tether home.
Okay. Mr. Murad?
So Judge, a couple of things I hope you'll indulge me. This might be a little longer than you may like. I'd like the court to know that Ms. Griffin, for starters, has no criminal history whatsoever, no pending matters against her whatsoever, was gainfully employed as a CNA at a nursing home as a caregiver, still receives government assistance. Now, we'd like the court to just be aware of Ms. Griffin's participation in this investigation because it's not prescribed in the report. This was the third time that the police have contacted her. The first two times she's voluntarily went into the police department with her mom and cooperated with the investigation and was let go. She is 8 weeks pregnant. I read the investigator's report. A few things that I would highlight here, Judge, is that the person who was actually shot, Mr. Lockhart-Simmons, was unable to positively identify Ms. Griffin as the individual who shot him earlier in the morning. The other things that I would add, Judge, is the forensic analysis of whether or not the firearm belonged to her, possessed to her. The conclusion was more likely than not, which is not definite. And I don't believe that would be sufficient to rise to the legal standard that might be required. But more importantly here, it's our position that she wasn't the only person firing shots. Obviously, this isn't the date to argue that. There is a self-defense claim here that is going to be made. But for bond purposes, if the police are letting her go after her complying, I don't think she's a real danger to the community. Had they told her this warrant was going to be issued, she would have walked herself in. It took almost a year for this to even be signed. Given her lack of criminal history, given the, I guess, non-fatal injury, which is by a year is probably recovered from, I don't have proof, I'm just speculating. I'd ask the court for a personal bond, maybe a GPS something to track her. But she's never been in any sort of trouble before, and she's been cooperating with the investigation. No criminal history or capious history. I think she deserves the benefit of the doubt, John.
Your Honor, if I just may briefly.
Yes.
There is video of this incident, Your Honor. There's video also of the security guard who can identify her as well. There's also two other people, and this is Taylor and a Miss Pippin, who can identify her as well. But the video shows her as well. So I believe that there's more than significant evidence that she is responsible for this action. And I think she is a danger, whether she's done anything since then or not. It's a very serious matter. Thank you.
Okay, court having heard argument as to bond. The factors the court's taking into consideration with respect to issuing this bond ruling is that it almost a year later before the charges were actually signed. The fact that the complaining witness was unable to identify Ms. Griffin as the shooter, notwithstanding other evidence to the contrary, but the complaining witness actually was unable to identify her. And I say that there weren't other witnesses that did, but the person that was shot did not. Like I said, given the time it took to bring charges in this matter, and the fact that she is in the early stages of pregnancy, I'm going to give her the benefit of the doubt and give her $100,000 personal bond, no GPS tether. While this case is pending, ma'am, you're not to possess any handguns, firearms, other dangerous weapons. No contact with Lamar Lockhart Simon. Public cause February 11th, preliminary examination February 18th. Both in front of Judge Dow. Step aside, ma'am.
Your Honor, he was shot in the butt. Good thing he was facing the other direction. I'm not arguing the case anymore. I just thought
Okay.
Thank you. No problem. Thank you, Mr. Ryan.
All right.
I can say it now. Lorena Ellison.
Thank you. Ms. Ellison, this is case number 250-5551601. People say Michigan versus Lorena Ellison. Appearances, please.
Jennifer Douglas for the people, P72748.
Brad Murad, P83665 on behalf of Ms. Ellison. We waive the formal reading. Ellison stands mute. She's been advised of her rights.
Court will enter not guilty plea on behalf of Ms. Ellison. Final recommendation from the people.
Your Honor, on Ms. Ellison, we do recognize that this dates back to November of 2022. I'm not going to object to a $50,000 personal bond. I believe that Ms. Ellison does not necessarily work there at the location anymore. So, Your Honor, at this time, I'm not going to object to $50,000 personal.
No objection.
$5,000 personal bond. Probable cause February 7th, preliminary examination February 14th, both in front of Judge Giles. Step aside. All right. Have a good lunch. I'll see everybody at 2:30.
See you guys.
Thank
you,
you, everyone.
everybody. Thank you.
Madam Clerk, thank you.
We gotta say five more.
Or in writing 5 days after first being advised of these rights. Jury fee must be paid when the demand is made more than 5 days after first being advised of these rights. All rights, rental and other housing assistance. 5 days of first receiving these advice and information. You must provide written proof to the court that an application for assistance has been submitted for processing. Housing assistance and rental assistance may be obtained through the Department of Health and Human Services, commonly known as DHH. They can be reached at their phone number of 1-877-696-6775 or through mibridges.mish.gov. Assistance may also be by contacting Housing Access for Washington County, commonly known as HAWK. HAWK can be reached at 1-1999. Additional assistance is also available in Washington County Veteran Services. Their phone number is area code 749734540. Also, you may obtain housing assistance and other resources through coordinated entry resources. Their phone number is 745-678. You do not need a judgment to obtain assistance from any of these agencies. The summons and complaint are sufficient. You have a right to reach an agreement outside Michigan and local communities through resolution programs or possible resources. Washington County Resolution Center. Area code 734-791-2125.
Okay, I mean, I know.
To protect your credit and future rental possibilities, your case may be resolved by way of.
Okay, I mean, that's not the problem.
If that is approved by all of the.
Well, okay, then you can have a seat, I can check them, okay?
It is important to understand these. If you have any questions, please feel free to address the board.
Case number 244C.
Yeah. Okay.
Sure.
So. Fortune. Gentleman Fortune.
On house arrest where you cannot leave your home except for work, court appointments, or medical emergencies.
Sí, señor, va a ser 2 días en la cárcel, inmediatamente va a estar en su casa, arrestado con un monitor, no podrá salir de su casa para nada, excepto para ir a trabajar, para ir a las cortes y o alguna emergencia médica.
Ok. El monitor, ¿cómo va a ser? Yo lo voy a, nomás van a poner así nomás.
How does the monitor work? Are they just gonna put it on me or what?
It will be your responsibility to contact electronic monitoring, and they will go through the process with you.
Es su responsabilidad comunicarse con la organización de monitores electrónicos, o en inglés Electronic Monitoring, para que ellos le expliquen ese proceso.
Pero lo voy a pagar yo.
Would I be responsible for paying for
Mika Claiborne.
I knew that. I just wanted to hear you say it. All right. Okay, where are we on this case?
Your Honor,
Okay, so
we have two cases that were before you today for a fourth hearing. You were working with the defendants and allowing for assistance to be processed. The other case will be dismissed. Ms. Claiborne's case, they have not made the commitment for payment. And I think she was in payment from Hawk. The balance that's due is $2,363 plus court costs. And I'm not sure what the status is. They haven't received written commitment from them.
So you haven't, on the other case, you've received the commitment, and that's why you're dismissing, but on this one, you haven't received the commitment.
That is correct.
may I speak, Your Honor? So, is
Can I
that okay?
stop you?
Okay.
Go ahead.
So,
Go ahead.
I just got off the phone with Alicia Sykes, who is my caseworker,
Right.
SOS, and she checked and she said it's not yet approved, but most likely will be at some point in time today. She just needed like the last couple documents from me last night, and I sent them to her. So it's like processing in the system. And so she said it will be for $2,363.
2,000.
363.
2,600.
Yeah. And then I also discussed with her that I will be making my February payment on the 5th, because I get paid the 5th and the 20th of every month.
Gotcha. Okay, so you're gonna make your February payment on the 5th.
Yes.
And this, give me that number again. Just say
$2,363.
363. And that, the 2,363, Mr. Hughes, that will cover the balance?
Of the rent through January, but not the court cost of 162, and February's rent will be due tomorrow.
Okay, so, right, so that's what I was trying to get at. So what our problem's gonna be this, not a huge problem.
Okay.
There's gonna be you pay your February rent,
Okay.
but what they're paying, that's correct, is going to not include the court costs.
Okay.
So you're gonna end up with 162 short.
Okay.
So let me ask you this. When you get the pay on the 5th, can you pay February plus the 162? Is that a possibility for you? I know.
Only because
The rental amount looks like it's 50.
it'll be 235.
Hold on. I'm sorry, Mr. Hughes.
The rental amount looks like it is $59.
No, they just raised it to 73. I actually just signed a document.
Oh, okay. So
I went in
73.
office, so it'll be 73 starting February plus the 162, so 235.
Yeah.
Can I split it in half between the 5th and the 20th of February?
Okay, let's do this then. Okay, because it's so close that we don't have the commitment, but you're saying they told you that it would likely be committed.
Yes.
All right. So what's half of 62, 81? So
when I pay the court costs, would that be paid to Arbor Manor or to you guys?
oh no, it's payable to them.
Okay.
Okay.
So
here's what we'll do. What I want you to do, and I'm going to do one last adjournment, because if it's approved today, they then should get the commitment. I want you to pay 154
okay.
by February 5th
Okay.
to the landlord. All right. What that is that's half the cost.
Okay.
And then what's going to happen is somehow or another, we're going to still have a balance of 81.
Okay. And I could pay that on the 20th February.
Right. The problem is I don't want this case to run out that way.
Right.
Okay. So we'll figure something out. If you happen to think you can squeeze that 81 out so this thing can be done with and get dismissed, I'm going to suggest you do that.
Yeah, I'm going to try for sure.
Because that will be the better way to go.
Yeah.
If we can do that.
That sounds good to me. I'll definitely do my best.
54 by the 5th. And I will adjourn this out one last time so we can get that commitment in to February 14th, my next date, February 14th, 2025 at 1 p.m. So the whole key here is if you can get that 81, the 152 plus that, or 154 plus the 81 in, then what will happen is on the 14th, it goes away.
Okay.
Okay.
Well, if I pay it before the 14th, will I still have to show up to court? Yes.
Pay the 81, you mean? So you pay the 154 on the 5th and then find the 81 between then and then we're good then too.
Would I still have to show up to court though on the 14th?
Why, you don't want to come see me?
I mean, I'm just asking.
This is how my feelings get hurt.
I know I want to see you, but you know.
Okay. No, you wouldn't have to as long as the landlord is clear that you paid it.
Okay.
So you have to make sure that it's paid enough in advance of the 14th.
Okay.
Okay?
All right.
Okay.
That sounds good. Is there a number for me to contact court if I just want to like double make sure?
You can call, Mr. Hughes, for you would suggest you call the apartment complex?
Yes, and if
Or
you
you.
can't get a hold of them, my phone
just
number
ask
is
them-
on the papers.
Okay, so call the apartment complex. If you can't get through to anybody, then call Mr. Hughes' office, and that's on your paperwork.
Okay.
Okay?
Got it. All right. Sounds good to me.
Okay, take care. We may or may not see you. All right. All right, take care. Court calls the case Forrest Knoll versus Daniel Cripps.
Thank you, Your Honor. Paul Hughes, good afternoon. P31986, appearing on behalf of the plaintiff.
Hi.
Hello. All right, where are we on this case?
Your Honor, this case was adjourned as the last one for processing of payment. My client has received a commitment for payment and has instructed me to file a voluntary dismissal without prejudice.
And ma'am, you have any objection to that?
Nope.
Oh, I didn't think you would. Okay.
Yay.
Yeah. All right, case is dismissed. Thank you, ma'am.
Thank you.
Have a great weekend.
You as well.
Is that it for Mr. Hughes?
Yeah.
Okay. Have a good weekend, sir.
Thank you. You too. Thanks, Judge.
Sycamore Meadows versus Travis Jamerson.
Good afternoon, Judge Carrie Zan, P67390. Your Honor, Ms. Lee is here. However, I've agreed to withdraw the request, the reinstatement request and order of eviction. We did restart. The restart took place last week, and we have a plan of attack for the rest of the payments. But if you remember
Yeah, oh no.
I know, Judge, I know, and I apologize for not being here last week. I was actually in St. Joe. Yes, Judge, and I'd much rather drive here, but some places call me elsewhere as well, so.
Understood. And who was on this?
Miss Lee was, but we discussed it and I told her I was withdrawing the request for the reinstatement and the order of eviction and that the conditional dismissal would stand. If you want me to go.
Is she in the building?
Let me go. Jill, did she leave?
I'm
Did she
sorry.
leave?
No.
Is she? Okay, let me go grab her.
I just want to make sure we. And Mr. Ziegler, are you there so I can call your case up next if possible? He is still not answering. Did he sign off and sign back in?
He has not signed off on the sign back in. Indicated that he's dialed in, but the number he gave me does not match the one dial that I have.
Got it. He's told you that he dialed it though.
Yeah.
Okay. All right. Well, we'll try to deal with that. All right. We're Sycamore Meadows versus Jemison.
I indicated on the record that I was withdrawing the reinstatement package and the request for writ and that we pretty much worked out the rest.
Yes, Your Honor, Tish Lee for Mr. Curvis Jemison. We don't have any objection to it.
All right. So motion withdrawn.
Thank you, Judge.
Okay.
Thanks.
That was easy. I thought that would happen with you too. Okay. I didn't mean to say that was in my head. I don't know how it came out.
I have those moments as well, Judge.
It just did.
I wear the red boots so that maybe I can get away with it.
With that? Nah. Sycamore Meadows versus Kayla P.
Oh, Your Honor, can I grab my things in the cyber?
You're on this one?
Yes.
No. Yes, go ahead.
For the plaintiff, Carrie Zan, on behalf of the plaintiff.
Kayla P.
All right, while we wait for your attorney to get back.
Yes, sir.
The individual who has signed in or dialed in one with the last three digits of 173, if you could please hit *6 on your phone and unmute and identify yourself.
Hello?
Hello? Who are?
Judge, my name is Gary Ziegler.
Okay. So first thing, Mr. Ziegler, whatever other, oh, he's just gone. Where? Oh, no. He's there.
Judge?
Mr. Ziegler, you
I'm here.
there?
Yes, sir.
All right.
I apologize. Obviously my computer is not Zoom friendly.
Yeah, you're
Hello?
probably right. It's by no means, I'm sure, a user error. Stay right
Yeah,
there.
I apologize for that.
No, it's okay. Let me call that case counsel and just Marshall Real Estate Group versus Gary Ziegler.
Ryan Sweeney appearing on behalf of plaintiff Marshall Real Estate Group.
All right.
Gary Ziegler here from Saline via phone.
Okay. And where are we on this case, folks?
So last time we appeared, Your Honor, Mr. Ziegler was set up with a social worker to assist in getting his application in this court. Ordered that it be filed with or provided to the court proof of the application being submitted by Wednesday of this week.
Yes. And I don't have that. I don't think. Hang on. No, I don't have anything.
I have a copy of it right here.
Yeah.
When did you send it to the court?
Monday afternoon, 4:00. So we're talking the 27th. It was supposed to be there by 4 p.m. on the 28th. It's the
Right.
Sears.
And okay, that might be an error on our part, and it just didn't get to my file. Your social worker was helping you get that in, right?
Correct.
Okay. So you're entitled to another adjournment because of that. I'm going to assume that he got it in, Mr. Sweeney.
Okay.
And what have you applied for? You applied for an SER, and then did you contact Hawk?
Yes.
Okay.
Nothing.
Did they give you an
Nothing.
appointment?
I've talked to people on the phone. I haven't been out. I'm partially disabled with side effect neuropathy, plus my car is currently inoperable and I don't have the funds to fix it. However, Amy, the court liaison that I've been working with since last meeting, has given me 4.5 pages of resources to work. I'm about 60% done with them, but Judge, one of the resources gave me an additional 223 resources. I kid you not. I wouldn't waste the court's time on this. Okay, so I have additional resources to work through, but I'm just going to be perfectly candid, save everybody some time. Here's what I'd like to do.
Go ahead.
Yeah, that okay. Point taken.
Go ahead, Mr.
Yeah, I know I need to give this, and I haven't talked to an attorney. Nobody's even answered the phone. All due respect. Swear to God. Okay. But I want to end this. Okay. And I know that I need to end this by paying what I'm due, but I want to try to work in the next 2 weeks to move out of here and at the very least give the Marshalls their apartment back.
Okay.
So in a nutshell, I know that, yeah, I know that's all fine and dandy, but no ticky, no laundry, bud. Right. You owe $3,750. If there's one of the resources that I just found was the dispute center. Obviously, I don't want an eviction on my record, But I'm headed there for sure, unless I, either cough up the money or move. I'd like, if I can be so bold, is to please ask for another 2 weeks work effort to meet that end, to at least move out of this apartment in 2 weeks and give the Marshalls back their apartment.
So Your Honor, what I'm hearing almost sounds like a consent for possession in 2 weeks. If the funds are not paid by that date, he will move voluntarily. And I would do that as like a pocket judgment so that no eviction would go on his record if he does actually keep to his word and either pay or voluntarily move.
Well, it won't be for lack of effort. That's all I can promise. Like I said, I don't even have, it will not be for lack of effort. Go ahead, I'm sorry.
It's all right. Here's what I'll do. And I'll take that into consideration if he doesn't move out in terms of the time limit, Mr. Sweeney, that will be granted on any judgment. But I'm not going to grant a judgment that way. But what I will do is I'll adjourn this out 2 weeks, let him see whether or not either he's going to come up with the resources to get it paid or vacate the premises at that point.
Yeah.
Okay.
Let me, Your Honor, if I could, one last thing. I have a tentative acceptance in 2 senior housing units, McNamara Towers in Livonia, and Dunn Family Co-op Apartments in Centerline. I've submitted the paperwork. I'm not only in line, I've been told by parties verbally, okay, not, in all honesty and candor, nothing in writing. They won't give you, for whatever reason, they won't give you even a tentative move-in date. But I am on the waiting list, and I am very high on the list. And in all honesty and candor, both of those places, okay, again, McNamara Towers in Livonia and Dunn Family Co-op in Centerline, which I would gladly take. Beggars can't be choosers. I'm in a tough spot. I need to go. I get that. Okay, so I have the deposit for both of those places, and I have a tentative agreement from my brother to cover the moving costs.
Okay, I get that. So here's the thing, Mr. Ziegler, you need to make a decision on which way you're going. I'm giving you 2 weeks to do that. Okay?
Understood.
All right, February 14th, 2025 at 1 p.m.
Thank you, Your Honor.
Oh, you'll send a note. Yeah, okay. Okay, you'll send a notice for that, right?
I'm presuming we will, yes.
Yeah. All right. Thank you, sir.
Thank you.
I can hang up, right?
Yep, you can hang up.
Okay, thank you. Thank you. Bye-bye.
Sycamore Meadows versus Caleb P.
Again, Carrie Zimmerman.
Jill Bauer on behalf of Ms. Peace, also present.
All right.
Judge, I know that last time I wasn't here, I got an email from opposing counsel regarding a stipulated order. I sent her a revised stipulated order as to what my client would be willing to agree to, meaning to give Ms. P sometime a date where she can get everything out of the unit and she can take anybody that she needs to take with. We're just asking that they wear appropriate face coverings because of the situation. I wasn't here. I heard through the grapevine of what happened. I just want the court to be aware it's about insurance bids. I mean, realistically, insurance bids and contractor bids and making sure that we have the appropriate people in the unit. All of the things need to be removed, Judge. It's soot filled. There's a wall that needs to come down. Am I correct? There's a whole wall that actually needs to be replaced. So it's not something where counsel wanted Ms. P to be able to leave items upstairs. That's a problem because the smell is going to stay. You know all of the things I'm going to say to you. And so I really just need all of her stuff out and then they can do what they can do. And that's where I'm at. That's what I can agree to at this time. And I
sent that order over to opposing counsel for review and they can pick a day.
Well, Your Honor, if they're willing to rehouse her, she would have a place to remove her belongings too. But she's living in her car right now.
Judge, I don't think that's quite accurate because my client has actually seen her with her grandma, who's also in Sycamore Meadows. So I could be wrong, but I believe that that's where they've seen her living and residing. At this time, Judge, I don't have the authorization to agree to rehouse her, and I don't think that my client's willing to do that either, from what I've been told at this point. So I'm willing to give her the time that she needs to get her stuff out of there so they can get in the unit and do what they need to do.
And we believe that they should be rehousing her. So we'd ask the court to.
But she's not in the unit. So I guess I'm unclear as to why you're holding the unit hostage.
Well, we're not really holding.
Put it bluntly. I mean, because that's what you're doing. I mean, they can't, if her things are in there, they can't do anything. And so I don't know who that benefits.
Well, Your Honor, I was not aware that it seemed to me that the damage was just in the kitchen and that there wouldn't be any work being done upstairs. So that's why I thought she could leave her large items upstairs because she has nowhere else to put them right now. If she was rehoused, she would have a place to put them. That's what I was thinking. I did not have the information that a wall needed to be replaced. That would make it untenable to store things on the second floor.
Okay. So now we are aware that that's the case. So what's defendant's position now? Because whether she's rehoused or not, you can't just hold this unit. I mean, I can issue an order that she has to remove her items, or she's at a certain date they're abandoned, and then they can remove them.
Well, I just heard with you that the second floor. So can I ask her if she has a place to move the larger items? Your Honor, Ms. P has items in the unit that she wants to remove, but she's willing to not take the larger items because she has nowhere to store them. But she just wants the court to be clear that she's not surrendering her right to the unit. She's just removing her things so that repairs can begin. That's what she's concerned about.
At this point, I think I've said it already twice now. My client's not willing to rehouse her. I don't, at this point, I just need her to get the stuff out so that we can get done what we need to get done. This isn't the first fire that took place in this unit. This is the second fire. So there's problems there, but I think before the court today is what we've discussed about removing the items. And so that's where I'm at.
The order that was sent over regarding removal, what was the date?
I just need her to pick a date. And so that the order says that within the next week, she'll pick a date and she'll be able to go on that date and bring individuals with her. Can I see the?
That's my order.
Oh, okay, Judge, I sent it to her. I thought she.
Okay.
It was one paragraph, Judge, and I'll read it to you. Defendant shall be provided a full day within the next week to go through her belongings and remove any and all belongings from the unit. Defendant shall be allowed to bring people with her to assist her. Defendant and anyone going into the unit shall wear protective clothing and mask while in the unit. So ordered. And if she wants to pick a date now, I can revise it and put the date and the time she'll be able to be there.
Give me a date.
She needs to talk to find out who can help her, but she will pick a date.
Okay.
before the 7th of February, so within the next week.
Okay, so here's what I'm gonna do. I'm not this way. Can't pick a date, I'll pick a date.
Okay.
It's February 6th.
Thank you, Judge.
Thank you, Judge.
So put that in the order, I'll sign the order, and then what do I need to do? Adjourn this case out to deal with the.
I have 2 other things that I want to put on.
Sure.
I'd like to add an explicit sentence to the order that clarifies that she's not giving up her right to be housed by emptying out the unit.
Well, if the case continues, of course she's not. She's
Okay.
challenged. I don't know why that needs. to
Okay,
be
I
there,
just
but
want that to be a part of.
Otherwise, she'd get her stuff out and we're done, but obviously we're not.
Okay.
I'll
The
be
other.
handling this when I get Social Security, apparently. Go ahead.
Okay. I think that the stove should be preserved for examination, since that's the key item about how the fire started.
Stove should be preserved.
And we'd like.
Is the cat gonna testify? I'm sorry. I thought I'd ask.
Judge, there's pictures of the stove and with the, I think they're attached to, there's actually pictures and in the fire report with showing that the stove was actually on, that the knob was on to turn. So I don't know what.
Yeah, I know, but the issue is whether or not a human being turned it on.
I don't know what the issue is, Judge. I understand very, very clear my issue.
I'm not sure how we're gonna resolve that, but.
I'm not either,
I'd
but
like an opportunity to see if I can find someone who might be able to weigh in on that.
I don't know how
Is
this.
cat still available? I mean, I just asked you a question because. Do you still have the cat? Okay.
Judge, I don't know how she wants me to preserve the stove. I have no way of preserving a stove. So unless Ms.
Well, I would imagine that Sycamore Meadows has some storage. I mean, I get the request because somebody's gonna show me how this.
There's actually a statement in the report from the fire chief that Ms. P said that when she walked in and saw the smoke, she heard the clicking of the stove and then walked back out as well. So I don't know how preserving the stove is going to change any of the evidence that's out there, but.
You want the stove preserved for what purpose? To determine whether or not there's
It could
some.
be started by an animal. I mean, that's what they put in their motion that I got yesterday.
But
is
that's
that-
what was in I didn't put that in the
But
motion.
that was a statement, I think, by your client
But-
to the fire.
But she recorded the conversation with the fire department. That is not what she said. So the fire report is not accurate.
Okay, well, to make it fair, You guys are gonna have to find some place to store the stove. The stove, prepare an order, gotta preserve the stove as well
If my
as,
client has no place to put it, what would you like me to do? Does Miss Bauer want to find somewhere to preserve it? Judge, because my client doesn't have storage. If they, I mean,
can you guys work out where to store it? I mean, because obviously somebody's gonna have to pay to have it, or
why doesn't she?
what do you want to do to this stove? You want somebody to go and tell you whether or not this stove can be turned on by an animal, right?
I'm sorry, Your
So-
Honor, could you repeat that?
I know, Miss Lee was all in your ear. So when would you get the person out?
I'll start working on it immediately. Maybe the stove could be moved to the basement since there's not going to be any work done in the basement.
Well, I don't know that. I mean, I'm not the contractor, so I don't know whether or not it's,
I mean, if
okay, so I'm gonna be serious about this for a moment. The stove needs to be put in some secure location. All right, you're just gonna have to, plaintiff is gonna have to figure that out.
that's fine, Judge. I'll figure it out.
Okay,
And then the last thing, Your Honor, is I finally got paperwork for the case this week. I'd like to file an answer on behalf of Ms. E. I need time to file an answer to the motion that I got yesterday, and then possibly draft my own motion for summary disposition. So I need time for those things with permission of the court.
how much time are you gonna need?
I would like 3 weeks. I don't know if the court would give me 3 weeks or not, because I still have a FOIA request that I'm going to be picking up today that seems to be pretty lengthy.
Judge, we're before you on the 18th of February. You can stick us on that date. If you're okay with it.
Probably not, but
Okay.
I mean, I will. But here's what I'm gonna do. I'm not giving you 3 weeks. You need to file it by the 14th.
Okay. Thank you, Your Honor.
And then I will adjourn this matter out. We can put you on the 18th.
Okay. Thank
And
you.
then we'll figure out where we're going. February 18th, 2024, 9 a.m. That's in person. You prepare the order regarding preservation and you prepare the other order and then I'll sign it. Thank you. I do also want a picture of the cat's front paws.
Can I just make sure that the things on top of the stove don't need to be preserved? You just want the stove put in a location in the basement or something
Yes,
like that? I can get rid of all of this, correct? Because I'm not gonna be able, the
Yeah.
problem with preserving everything that's burnt on the stove is the same problem with all of the stuff.
I don't
in-
think we have pictures of that. I think we're just interested in the mechanics of the stove being able to be examined. So that's fine.
Okay, thank you,
Okay.
Judge.
And I want pictures of the cat's front paws extended as well as the rear paws, not that those are as important for me.
Okay.
Thank you. Sycamore Meadows versus Derrick Hall.
Here it is, Anna, now we have to play.
We have not filed an appearance in this case, but we have one ready to file, and we just decided today that we will be able to represent.
Wait, I'm sorry, is this Mr. Hall? I'm confused, then why was that presented with an answer filed by Mr. Hall and you're now gonna file an appearance?
I just handed it.
That's good. Are you filing an appearance or not?
Yes.
So does this stand or are you going with something?
This stands. We just decided just now that we would be able to file appearance. I apologize.
Okay, so I guess what I want, I think what counsel for plaintiff is asking, I don't want to get into a circumstance where at some later point, they're asking to amend the answer because it was filed in pro per.
Well, literally, just before you called the P matter, I was handed this. I was told that it's the answer for Mr. Hall. That's what he's filing. So it was that part, and it was also the part of confusion because I was told one thing less than 10 minutes ago, and now I'm being told another.
Okay, are you listed as the attorney of record on that answer?
No, Judge.
Then if you're going to file an appearance and are representing that to the court, your name needs to be on the answer because you're the one that is signing regarding what is contained in that answer. So when will you get that all corrected? And I'm not going to require any type of response to what you received today.
Thank you, Judge.
We could get that in.
Answer in a week. All right. And then we're going to need to take a look at everything. So I might as well just adjourn this to the 14th, February 14th, 2025 at 1 p.m. See where we are. Thank you, sir. Sycamore Meadows versus Jasmine Fortune.
Carrie Shannon on behalf of the plaintiff. Don't. Is here, call his name out. If you recall, this was actually a case where she was waiting for a hawk payment. She did get the hawk payment into my client. It brought her balance down to, sorry, let me just find the file.
No, it's fine.
There's a total balance of $474. That includes court costs. So there's a $284 plus $190 in court costs for a total of $474. I was hoping she was here so I could do a conditional dismissal with her, but she's not. I guess I could ask for a default judgment at this time, and if it's paid within a certain period of time, plaintiff will set aside and dismiss the case.
That sounds, I think that sounds fair. So I'll grant a judgment for possession. Total amount is how much?
$474, Your Honor.
That is the redemption amount. I'll do that by default. And then
Further orders will say if paid in full. I'm going to say by February 14th, 2024, that plaintiff will set aside and dismiss. Okay.
That'd be great.
I'm going to hand jam one.
Okay.
Thank you.
So hold that one. Well, yeah, just hold it because she's gonna. Sycamore Meadows versus Christine Mason.
Okay, plaintiff.
Your Honor, we've been trying to work out this case, without representing Miss Mason, but we just made.
I don't know how you do that. I get it, but
we're gonna enter an appearance because there are significant issues with her ledger. All of the charges that are being assessed against her go back to previous management. They don't align with her income. They haven't been able to produce research.
So are you filing an appearance?
Yes, going to be filing an appearance.
And then you'll file an answer, and
Yes.
will you do that?
We can file the answer on this one probably by next Thursday.
We have a judgment on this one. This is a problem I have, Judge. We've adjourned this now a couple.
You do. You're right.
We have a judgment on it. We've adjourned this a couple times because Ms. Mason was trying to get funds. I'm understanding that I thought she was approved for Hawk. Am I incorrect? 3,000 for Hawk, correct? And then you were approved for another amount, 200 from another agency, because the last time we were here, which was, I believe, a week or 2 weeks ago, she was just trying to come up with the balance. And so now we're making it more convoluted. And I'm just, if that was the case that they wanted to do, why didn't they do it in the beginning? 4, 6, whatever weeks ago it was. Why are we doing it now when Ms. Mason has put on the record multiple times she's just trying to get the funding, and obviously we're working with her?
Well, we were waiting for documents and we didn't find out until last week that they don't have the research that we were asking for. So then I had Ms. Mason provide us with tax returns And we see that the amount of rent that she was charged is way out of alignment with what her income was for the years that this balance accrued. She's been on zero rent since January of 2024. So this is all old. These balances are all from prior management that can't be justified with paperwork.
Requests were made. I went to client. They don't have them. Previous management had them and didn't leave them in the file. I indicated that to them. However, again, I'm sitting here and they could have filed an appearance multiple times ago and now we're doing
Well,
it.
until we didn't know that the documents existed, we didn't know that we had to go about challenging the balance in a different way.
I guess my problem is we're submitting paperwork or ledgers for a balance, but now we're saying we're gonna contest the balance. So when we're submitting it for us assistance and funding, it's okay, but now it's not because we don't have enough to cover the balance. I find that all a little disingenuous as well, but.
There's the judgment amount back in December was 51.79. As we sit here today, I don't know what her January was zero, correct?
Yes, Your Honor.
The balance is actually a little bit lower than that, Judge.
It is, what is it now?
The total with the court costs would be $5,004, Judge.
Okay, so now we're at $5,004 that's owed. What that means, and I'm trying to figure this out, but I thought, as Ms. Zanin has said, that it was really an issue of finding the money and giving time for that to happen. So when I look back at my notes in the file, I'm a bit surprised that we'd be at this point. Because if 3,000 comes from Hawk, there's 1,000 in escrow. I now have $1,004 that somehow we find, but now want to go into everything. And I don't, and quite frankly, I'm not even sure how we would figure all of that out without just a guess. Because you're going to go back, you're going to use tax returns. The documents don't exist. Previous management isn't here. So I don't know if she complied with her part of recertifying or it was management. I don't even know how I would figure that out.
We're actually at $800. If the balance, if I show $5,004, 3,000 Hawk, 1,000 in escrow, plus 200 is the other agency that.
Oh, right.
So
right.
we're at $800.
Your Honor, all I can say is that until last week, we didn't know that we were going to that we weren't going to get the documents to review the ledger. For example, in 2023, her total income was $7,800 and she was billed $500 a month in rent. And if they had been properly doing her recertifications, that would have been caught because she lost income in December of the previous year.
Was that reported? I mean, you're asking me to make certain assumptions about things that I'm not sure, even if given a trial, I could make those assumptions.
Your Honor, I think if they had been properly recertifying her, they would have checked her income at the time of recertification and seen that it was much lower than the amount of rent that she was being billed.
And sometimes people lie on their tax returns. I mean, what do you want me to, that's gonna be part of the problem. You're asking me to just default to that side, and I don't know that I can. I mean,
Because we actually have a bigger, we have a stepping stone, the default judgment.
pardon?
We have a judgment that's in place.
Oh, I know,
Oh.
I know, I know. I mean, I'm just,
And there's a court rule that's very clear about.
I know.
Okay.
Your Honor,
Thank you for reminding me of my job.
I'm not.
No.
I'm just making my arguments.
No, I understand.
Your Honor, procedurally, it's the plaintiff's duty to prove that she owes what they say that she owes, and there's a motion to set aside.
No. You have to give me, we're at a point in this case where you have to give me a defense. You have to give me a meritorious defense for me to set aside this default judgment.
And that's what I was wanting to do, is enter an appearance and provide an explanation of why we think the judgment amount.
Okay, but Spauer, here's my problem with this. We go through a process of trying to preserve people's houses. They don't appear at the second hearing or the first hearing. We then come later on and everybody is sort of in agreement and where you guys come into the case, say you're not gonna enter an appearance, and I guess get that maybe. And that it's really about just getting the amount. And so the whole process through Hawk, and I won't go into my feelings on the time on that, but it works itself through. She gets the 3,000. She's posted herself $1,000 in escrow. There's $200 from some other place. And then we get to this point, and then the argument becomes, well, the number's not right. And, I'm not. My frustration is that, quite frankly, I really don't want to play games with this. What I want is Ms. Mason's tenancy preserved if it can be. And I thought that's where we were all headed. But it seems like now where we're headed is that we're gonna have litigation on litigation about what amount is due. I mean,
There's still an $800 gap that may be able to be addressed with inaccuracies in the ledger, and then she would have assistance to cover the rest of the balance, and her housing would be preserved. But she's still short $800.
I know. And so while I'd be sitting here trying to figure out, do math in a ledger of something that, quite frankly, as I anticipate, I'm not going to be able to determine. What efforts are being done to get the 800? Because she's currently at 0.
Yeah.
So it seems to me that all of this effort should be spent getting that money in between.
We are, we're trying, we're working on multiple fronts, Your Honor.
Okay. So she filed her motion regarding the default. Of rights right now, I could deny her motion. After all of this work, I could just deny her motion, and then the writ goes forward. And where have we gotten Ms. Mason? Pardon?
You said, where have I gotten the rest of the money?
No, what I'm saying is,
No, we don't want her to lose her housing here.
I know, and that's what I'm trying to point out. I've got this figure. So if we want to play the procedural game, we can. Or we can look at just doing what I thought we were doing. So I'm going to pass the matter. Ms. Bauer, you can talk to your client and let's figure out what we're going to do.
Okay, thank you, Your Honor.
Court calls case Sycamore Meadows versus Kimyata Hudson.
Again, Carrie Zanon on behalf of Planter.
Hello. What's your name? All right. Where are we on this?
Judge, at this time, $1,082.90 is what's due, court costs of $190, so a total of $1,272.90. This is utilities. She was supposed to get the utilities in her name, but it just recently we found out that your sister's putting utilities in your name.
Yeah.
So
what happened?
Her
My
sis,
sister had utilities in my name and she didn't pay it all. So I wasn't able to do it.
have you, I thought you had an appointment with Hawk, because Amy told us that last time we were here.
I missed her call. My phone had broke. And I got a new number.
I thought last time we were, no, I'm not trying to throw you under the bus, but I thought when because Amy was on, there's Amy. Amy, didn't we verify her that her phone number was a certain phone number because we were having a difficult time?
Remember?
Yeah,
me
that
too.
phone had just broke.
Okay.
I just got a new number.
Do you have any update for me on Miss Hudson?
Your Honor, with Ms. Hudson's permission.
Ms. Hudson, you give permission to
Let her look in your file.
Your Honor, it appears that there was the twin appointment, but the caseworker had not been able to reach her and left a voicemail. I'm hearing that there's a change in phone number, and I'm wondering if that could be shared, at least with your clerk, so I could convey that over to the caseworker.
the phone number.
That, yeah.
So yeah, if she gives it to my staff, we can shoot that to you.
Thank you, and I'll pass that over immediately to the caseworker.
All right. So let me ask this. Is this number increasing at all?
I don't believe that it is, right? It is?
Right. Okay.
Yes, but just the utility part, right? Nothing, because she's a zero. So it is just.
She's at zero
yeah,
rent.
Yeah, so it's just the utility.
But the utilities.
Okay.
And can somebody ballpark what the utilities are? 250? Okay, you're gonna be able to get your utilities paid for February?
Yes, I'm trying to.
Okay.
Can we ever maybe put something in escrow with you and then come back on the 14th and see where we're at with cost?
Okay, yeah, but when you say you're trying to, what do you mean, young lady?
I'm trying to switch it still in my name.
So it's still not in your name?
No.
It's in the complex's name?
Yes. Which, yeah.
All right,
I
so,
figured out why, because that payment my sister did, she didn't.
pardon?
I said, I figured out why it wasn't in my name because of my sister.
Got it. So can you get $250 and pay it in the court escrow?
Yes.
Okay, so when can you do that?
Can try by February 20th.
Okay, I can't go out that far. You have no sources of income right now, right? So young lady, let me ask you this, okay? Let's say you get the utilities into your name, okay? How are you gonna pay the utilities? Because here's what's gonna happen, and what I'm worried about. You'll put the utilities in your name. All of a sudden, you can't pay it. They'll shut it off, but really, it's gonna go back into the landlord's name, and then we got this problem again.
I have a bigger problem, judges, because she also gets a utility check
and she's not using that utility check to pay utilities. That's what I'm being told. And I can tell
So how
you
much of a utility check is she getting?
$157 for, this is what I'm looking at.
It's 157.
How much?
It's 157. I haven't cashed it.
157.
You haven't cashed it? What? Okay, so what do you, she said she hasn't cashed it.
Okay, well then she can,
Okay, so you. All right. Here's what I'm gonna do. That 157, you need to take your hands out of your pockets. That $157 check, you need to cash it, get it into cash, pay it into court escrow. Okay. And I want that done by Tuesday the 4th. Okay. And then I will adjourn this out to February 14th, 2025 at 1 p.m. All right. What I need you to do, we need to get her a piece of paper and a pen. I need you to write down your phone number. What I'm going to do is we're going to take that phone number, get it to Amy, who will then get it to Hawk so they can contact you. Okay.
Okay.
Carlos, is that everything for you?
that's, yeah, except for the one that we cast, I should, yes.
Are they ready or no? Okay. Carl Stafffield versus Chloe Peak.
Hello.
I'm Audrey Lee. I'm a student attorney with the Michigan Clinical Law Program with my partner Ellie Sawyer. And I'd like to request permission to represent the defendant pursuant to MCR 8.120 under the supervision of attorney Mira Edmonds.
Do I want to do that? Have they been before me before? Have you?
Yeah, we were here just last week. We got adjourned to
That's
this.
what I thought. Okay. All right. So I won't put you through my intense grilling. Permission to practice is granted.
Thank you, Your Honor.
Okay. And I had a hesitation on that for one reason. And come here for a second. Okay, they put it here. Fine. Never mind. Hey, I'm not gonna ask you that. Never mind. I'm good. Okay. All right. What are we doing?
Yeah, so
What
this
are
is
we
a
doing on this case?
non-payment case with a supplemental complaint for back rent. We filed an answer and counterclaims last week, and then we adjourned from last week because Mr. Stafford hadn't had a chance to read the answer. It doesn't appear that he's here this week.
Stafford? He's not present in the courtroom, and I do not have him. You don't have him checked in. All right. So, counsel, what would you like me to do?
Well, we'd actually like to continue to pursue our counterclaims in front of you. And we also, it came to our attention that there's some lack of clarity as to whether Mr. Stafford or Azar Stafford, who we understand his wife owns the property. So we want to ask for leave to amend our answer to include Azar Stafford.
Okay. I know why he's here. Or not here. He moved to dismiss his complaint. I signed off on the dismissal of his primary complaint, but the counterclaims, hold on, but the counterclaims remain.
All right.
So the only thing that exists are the counterclaims.
Okay,
I'm presuming he was served with the counterclaim.
Yeah, we served the counterclaims with our answer last week. We did want to amend the answer to include Azar Stafford as well.
All right. I will grant petition to amend. Add the necessary parties. You'll have to provide in that amendment, the basis upon which you're adding that party to the case. That also would have to be served on both the counter defendant as well as the new party. To allow that to happen, I will adjourn the matter to the 14th, 2025, 1 p.m.
Thank you, Your Honor. Would it be possible to pursue some limited discovery before then as well?
Why don't we get them served and then I'll figure that out.
Okay, appreciate it, Your Honor.
All right. Okay, thank you. And Ms. Edmonds, how are you?
I'm good, Judge. It's so good to see you. I'm spending more of my
Yes.
time on the juvenile docket these days, but I
Pardon?
jumped at the chance to say hi today when David needed cover.
Well, fantastic. And I appreciate that. Fantastic. You'd rather spend time with children rather than me.
I mean,
Well, they're children of different types. I get it. All right. Thank you.
Have a good afternoon, Judge.
You do the same. Donald Heyman versus Angela Heyman. Is it Chenard? Yeah, sorry, diabetic. All right. Okay.
Yeah.
State your name. Donald Hammond.
Angela Schnarr.
All right. This is the termination. All right. And what's your response to the termination?
Okay.
Pardon?
I'm not sure what to say, but okay.
All right. Go ahead.
Her worker, caseworker is Mrs. Jeplin, and she is working with her to get her help.
Got it.
I don't know how.
I haven't been able to work since I moved back into home. Parents haven't been able to work.
Okay, let me ask you this. What agency is your caseworker through?
Not sure.
Adult.
Taking care of everything against me, against my will.
Pardon?
Oh, go ahead. I'm just saying he's taking care of everything against my will.
Who takes care of everything?
He has been trying to, I don't know.
Okay, hold on a moment. What's the relationship here?
I am her father.
Got it. Okay. And were you why do you have a worker?
I'm not sure.
Okay, Dad, can you?
Adult Protective Services. She has problems with. I'm okay.
Got it. Regardless of what that was, the state stepped in for her.
Mental capacity.
Got it.
Trying to keep it clarified.
So the state stepped in.
Yeah.
Got it.
And that's where Mrs. Joplin came in.
That's what I'm trying to figure out. Okay, got it. And so they're trying to find her housing.
They want to find a guardian.
Wow.
I have leukemia, so I'm not capable of it to do it. So Mrs. Joplin is trying to get her a court-appointed guardian or counselor, whatever you want to call them. And she has started getting her state help.
Got it. Okay, thank you. So do you know whether or not a petition in probate court has been started?
I have not been informed one way or another about it.
Okay.
All I know is Mrs. Joplin is taking care of it.
Trying to, okay.
Yeah, trying to take care of it.
Okay. And you know about that? Has she talked to you about that? Okay.
She has been to the house and she has talked to Angela about it. But Angela does not seem to be
A little bit.
responsible.
To Ms.
responsive.
Joplin?
I'm pretty responsive.
Okay, so, okay, all right. I don't know that fathers and daughters always often can disagree about that, so I'll just let that happen.
You're
I
right.
moved in and I was helping him out the house, housekeeping. And when he had leukemia, real bad, I was helping him with that.
Okay,
Giving him his medication for that. And
okay,
everything that I'm like, kick to the curb, you know.
okay, all right. So, Ms. Joplin, if you asked her, you think she'd come to court with you?
I had told her about the hearing today. She was going to try to make it. She must have gotten tied up.
Tied up or something. Okay, because I don't, given what's being said, I'm a little bit hesitant to proceed. I'm a little bit hesitant to proceed with anything at today
That's fine.
because her here. So here's what, young lady, here's what I need you to do. Whether you think what's happening is right or wrong, okay? You need to communicate to Miss Joplin that she needs to be here at the hearing, okay?
I need her phone number. They didn't really, you know, they had given to me to keep in touch with her.
Okay, but doesn't she, have you talked to her?
She would just drop in and talk with him first and then come up to my room and then talk to me.
Talk to you? Okay, so here's, okay, all right, I got
Talks
you.
to him and then
So,
how it goes.
so here's what I want to have happen. Dad, if you could let her know, I get that. And then after, when she shows up to talk to you, I need you to tell her that you need her at the hearing also. Okay?
Yes, sir.
So let me adjourn the hearing in this case. I'm gonna go February 21st, 2025 at 2 p.m. And I'm putting it out a little bit longer just to give enough time for her schedule for its packed.
Thank you.
And then also what will happen is if there is a petition that's going to be filed, that will also give hopefully some space and we'll be able to figure it out.
Okay.
All right?
Okay. Thank you.
Both. Court calls the case, the people are Jared Lepick versus Andrew Elliott.
Hello, Your Honor. I'm Jordan Lepick. I'm also on this case. Jared Lepick
Yes.
unfortunately was diagnosed with influenza A this morning, so he has his Zoom going and can mic in if need be, but he's got very little of a voice left at this point.
Okay. All right. And yes, I do see him signed in. All right. Andrew Elliott or Traversia, is it Burrell?
Traversia Borelli.
Okay, sorry.
That's
All
all
right. Okay, what are we doing on this case?
Last week, sir, you had asked if they be out of the house before the hearing today. And as of right now, they're still moving stuff out of the property. There's still people on property, including a couple of unauthorized additional roommates that weren't included in the lease. And we have yet to get in contact with Mr. Elliott. He is the named person on our lease. So we would just like to see what his status is. We haven't heard from him since the 7th. And the last thing we received from him in writing was an email admitting to the debt owed and the wrongdoing on his part, stating that he can provide the court of a copy with this email. In his own words, he states, "We will obviously not refute what you are owed. We have no intention to. We would honor the court decision of the debt, which would additionally include legal fees. Given our contract is under the laws of Michigan, there is very little that can be garnished as the bulk of my earnings are earned as independent contractor." In this email, he proposed a payment plan that we were uncomfortable with agreeing to because he's offered us specific payment arrangements over the last.
Can I stop you, please?
Absolutely.
All right. How much are you claiming is owed?
So as of right now, he owes $15,000 plus court costs of $234.43. If I may, could I give you like 90 seconds of backstory, sir?
Not really.
Okay.
Your Honor,
I
if
don't
may.
know that I'm necessarily gonna need it.
Okay.
Ma'am, are you moving out?
Yes, we've returned the key. I have a couple of friends currently helping me move out the remaining things. I'm actually at the U-Haul Center right now, and they are getting the rest of the items out presently under the supervision of the land manager.
Okay. So, and ma'am, are you disputing the amount they're claiming is owed?
I am. You are? Yes, I am. We owe.
How much do you think you owe?
So we owe December and January. That's $10,000. We paid a $1,000 late fee in November and a $2,000 late fee in September and October. We believe that these should be subtracted from the total owed due to illegality of those fees. Also, we were subjected.
How much is monthly rent?
Your Honor, monthly
5,000.
rent is $5,000 a month. This is a 4,000 square foot house that we were under contract for them to purchase. And we have done a series of short-term leases as they were waiting on the sale.
Okay, so here's the thing. Is she right about, she just listed off, I think, $4,000 of late fees that they paid?
No, sir, that is incorrect. Those were from the previous lease. See, at first we did a 60-day lease, and then we extended that once their house was not sold. So we have 2 prior leases to this short-term lease, and we only enforce late fees on one of the months under those leases. And I can submit documentation of all this, sir.
So can I.
I do have claims that ACHs were sent that were never received to my account, sir, as well as proof of funds that I received in December and no payment was made out of that. The last communication I had about a payment arrangement was on December 13th, and I was informed by Mr. Elliott that day that his wife had sent an ACH. However,
Okay, look, folks. Oh, ma'am.
Yes.
Here's what's gonna happen. What date are you gonna be out of the premises?
We're already.
Your stuff
You're
is still
already out.
Right.
Your stuff-
And
They're
they
in the
have surrendered the
It's in the
keys?
yes, and it's in the process of being removed as we speak. So we are out. It'll be another hour or 2, I think, before it's all of our stuff is gone.
So then the only issue is what's owed.
Right. I also want to bring up, if I may, Your Honor, we were subjected to a wrongful lockout, so we are due 3 times damages of the $150 for a locksmith as outlined in Michigan's anti-lockout statute, totaling $450, which I also have evidence of.
Okay. All right,
Your
look,
Honor.
folks.
Your Honor, I'm
Yes.
in my house because they failed to pay rent. I have 6 children. These people make $350,000 a year is what they claimed on the rental application. I'm going to lose health insurance tomorrow, and my house is going into a foreclosure period as of tomorrow is 90 days late. They have money. They had subletters or whoever living with them, and I don't know if they were running a homeless shelter, if they were pocketing the rent that their roommates paid. They've
No.
just been sitting in my house, sir.
This is incorrect.
Okay. All right. So here's the thing. Possession has been granted. There are 2 parts to the case. Possession's been granted or surrendered to the plaintiff. So
There are,
possession is not,
sorry.
pardon?
There are still people at the house. One of them had a residence established there apparently. They're still at the house, and unfortunately our property manager expired at noon today, as it is the last day of the month. So any clean out of anything left behind, I'm going to have to go assess for any damages left on my own next week.
All right. Okay, so here's what I'm gonna do. They've surrendered possession of the unit. Ma'am, to your knowledge, are there people in the premises?
Yes,
Ms. Burrell, are there people still in the premises?
I don't know. I would have to text them. I don't know if they're on the premises presently, but we were told that we could get the remainder of the items out. So they would be doing that if they are not presently at the U-Haul Center where I am now. I'm just
So
using
here's
my
what I'm
phone
gonna
to do
do.
this.
Possession to the premises has been surrendered. Ma'am, as of, given everything that I'm hearing, your management contract expires, what, at midnight tonight? Is that the deal, or?
Yeah, yes. And we can't afford to pay
All
a
right.
property manager anymore.
Hang on, I hear you. I'm just trying to, because you're in North Carolina, right?
Yes, sir. But I will have to make
Okay.
a trip up to North Carolina to assess anything left.
I know. I'm just, I guess you're out of state. You've got a property manager here that won't be the property manager tomorrow.
Yes, sir.
So what? I should let you guys talk and then I'll just go back and then come back out. Because either you're gonna listen to me or not. Possession's been surrendered. I'm going to give the authority, I'm going to grant to the plaintiff the authority to prevent waste under 4.201I, that you may lock and secure the premises effective 3:00 today. The reason I'm doing that is so that you can get your property manager, go over there. You can order a locksmith, you can change the locks at 3 p.m. today. Whatever else needs to get out, if you don't get it out by that time, you said you surrendered, you're giving them the keys, they giving you grace to get some of the stuff out. If it's not out, not out.
That's
But the
perfectly fine, Your
premises will
Honor.
be locked.
Thank you.
Then the issue regarding the money is going to have to be done. Now, I might as well, because the parties don't seem to agree, set this matter for trial. You have to come up next week. Is that correct, ma'am?
Yes, sir.
Okay, so trying to time this, if you come up, how long are you going to be up here?
Very short amount of time, sir, as I have children in North Carolina in school. So a day. Enough.
So if I I was just gonna set this for a trial. So I can set a trial date, but I'm gonna need the parties in person because apparently there's gonna be a lot of documentation. So I'm trying to set it. So here's what I'll do. Because we're really talking about the money, but we got to get the premises secured first. So we've dealt with that. What's my date, March? The 4th? The 11th. All right. So what I'm going to do is I'm going to set a non-jury trial as to the money issues for March 11th, 2025 at 9 a.m. That's in person. So I've tried to set that, ma'am, I tried to set it out far enough so that you could make arrangements or do what needs to be done to come up. We'll hear it that day. So if it has to be a one-day trip, it's a one-day trip, but I've just tried to put it out to, well, I think you get what I'm saying. Okay?
Absolutely.
But I'm allowing you to secure the premises. You're gonna come up here, check on it. That way you can assess what damages or other things there may be there. Bring ledgers, all other documentation you want the court to look at on March 11th, and then we'll hear your case. Okay?
Your Honor, might I ask one question?
Sure.
Rather than pushing it out, I can make arrangements. I will make it work. Like I said, we're actually going into a 90-day foreclosure period tomorrow. And so time is kind of essence.
Got it. Then the best I could do is the 18th. What day? Yeah. But the best I could then do is February 18th. I could push it up to that day. Will that be better for you?
Yes, sir. Thank you so much.
So non-jury trial in this matter then will be set for February 18th, 2025, 9 a.m. Okay?
And one more question. Will Mr. Lepek have to appear as well, or will me be appearing sufficient just because he can't afford time off of work right now?
Well, he might want to have himself, if you're here, he may want to have himself. I will allow understanding childcare, work, those things. I would allow him to appear via Zoom.
Thank you. And as far as
So
Mr.
that he's present, but you will have to be here in person.
Understood. And Mr. Elliott?
He needs to appear. If he doesn't appear, then I do what I got to do.
Okay. Thank you, sir.
Your Honor,
Thank you.
may I ask a question?
Sure.
My partner might not be able to get off work either, but I can show up. Is that a problem?
I will give you the same, I will give you the same opportunities that I give the other side in fairness. So you may appear, but he would have to be available via Zoom.
Okay, thank you so much.
Thank you.
Thank you.
Michael Scott Stone versus Kevin Smith.
Yes, Your Honor.
That's your names?
Michael
Kevin
Scott
J.
Stone.
Smith, sir.
Where are we on this one?
He has failed to pay me any rent or for the utilities since June of last year and refuses to pay. And I wish you to order a 10-day where he'll be removed by the sheriff within 10 days.
And did you send a copy of this information to him?
Yes, sir, I did. He received it yesterday at 2:33 p.m.
You have the documents?
Yes, text messages and yeah, it's nothing, Your Honor. He's just.
So I'm gonna have to
confuse
set
you.
this for trial. I do my trials in person. You're down in Florida. He's here. When I read through them, they're at least what potentially could be colorable defenses. I don't know until I hear the testimony.
Your Honor, I'm a working man. I make $24 an hour and I'm paying his rent and utilities. I'm living off credit cards.
Sir, you know, every time you come here, you try to tell me how this is gonna be.
No.
You have property here in Michigan. You may be down in Florida. You may be a working man. I consider myself that too. This happens to be my job. Part of my job is setting a date for these trials to get them resolved. Now, if what you want to do week after week is sit here and try to lecture me on what Michigan law should do, then I'll just keep setting it every week. He'll come back. You'll just try to give me that lecture and we'll just move on. I'm trying to resolve the case. So I'm going to set a trial date.
So today's not the trial date?
No.
Okay.
I'm going to set a trial date. Maybe you didn't appreciate what I said. That
Yes, sir.
trial date will be in person.
Well,
If you had listened to the case before, I realize there are people out of state. I will try to accommodate that the best I can. So I'm going to set a trial date in person. I can set it for February 18th or March 11th.
Your Honor,
Your
can I have-
preference?
Can I have an attorney represent me there?
February 18th, sir. The reason being is because
I don't care.
Yes,
I
sir.
didn't ask that. Can you be here February 18th, sir, for a trial?
Can I hire an attorney to represent me there?
Pardon?
Can I have an attorney be there present for me?
Absolutely. You can have an attorney here.
Okay.
That might be wise, because then I don't get lectured.
Yes, Your Honor. So,
Non-jury trial in this matter
Your Honor.
will be
Uh,
set February 18th,
Yes, Your Honor.
2025, 9 a.m. in person. I
Your
will
Honor,
allow testimony over Zoom, but there needs to be a party here. Yes, sir.
Is on what basis is any of this evidence going to allow him to continue to stay there free? I don't understand.
Pardon?
There's nothing in any of this that it gives him the right to continue to stay there for free. I don't understand.
Then get an attorney, and then maybe then you'll have some clarification if you listen to him.
Okay. I don't understand his claim of how he can continue to stay there for free. There's nothing in those paperwork.
Okay, just because you rephrase the question doesn't change my answer.
Okay. All right. So I will have an
Sir,
attorney.
you had a question?
not a question, Your Honor, a statement that I would like to make, please.
Oh. About what?
Mr. Stone and the status of the condominium, sir.
And the status of the condominium?
Yes, sir.
In terms of, go ahead. It's got to be brief, and I may cut you off.
Yes, sir. Very brief, very short. Mr. Stone has known since, I'm sorry, Your Honor. Mr. Stone has known since 2022 that he should have the place registered as a rental property. Mr. Stone received.
That is a defense, and that you will raise at a trial.
Yes, sir.
I set a trial date, and God help me, I'll be here to hear all of it.
Yes, sir.
18th,
9 a.m.
9 a.m. in person. Thank you.
Yes, sir.
I don't want to call it another.
Yeah,
No, I'm not calling yours. I gave you guys like an hour. And now, never mind. Northwood Properties versus Brianne Porcia. Don't look at me like you don't know how I work. Two attorneys.
Yes.
Oh, yay. Mr. Drukas and Ms. Kim have signed off on a conditional order to dismissal. This case is conditionally dismissed. Are they here yet? Oh, hold on. Are the parties here?
Yes.
Court does call the case of Sycamore Meadows versus Christine Mason. You're welcome. All right.
I said it, just not very loud. Carrie Zan on behalf of plaintiff, Your Honor.
Jill Bauer on behalf of Ms. Mason, Your Honor.
It's my understanding that they've submitted a request for some funding for 800.
Did it.
Yeah. Fervently typing, when she was fervently typing, she was sending a request for some assistance for
The balance.
the balance. So if you could give us an adjourned date, I think we'll have this resolved.
No, you will have it resolved.
You're-
February 14th, 2025 at 1 p.m.
Thank you.
Thank you.
Have a weekend, Judge.
I will.
Judge, I'm throwing a frozen first birthday party for my grandbaby. So
Ah, fantastic. Have fun.
thanks.
That sounds good.
I just want to tell you about.
Oh, yeah, she's leaving me.
Yeah.
Oh,
She wants to say
So I just wanted to say goodbye, and it's been a pleasure.
thank you.
I'll keep watching my YouTube.
All right. Well, thank you. Thank you. All right. Take care. Godspeed to you.
We're in the main for an interpreter, Your Honor.
You may.
Good afternoon, Lee. You're from the Honorable J. Cedric Simpson out of the 14 District Court, Washington County, State of Michigan. Our number is 1423. You're muted, ma'am.
Thank you for calling Language Line Solutions. This is the ID number 216267. I will be your Mandarin interpreter today. I'm about to serve you. This call may be monitored for training and quality assurance purposes. May I please have your 4-digit access code?
23.
1423.
Yes, ma'am.
Thank you. Thank you. I'm ready.
All right.
Please raise your right hand and record. Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Mandarin and from Mandarin into English in the manner now before the court, so help you God?
Yes. Yes, I do.
Thank you.
And good afternoon, Madam Interpreter.
Yes. Good afternoon.
The court calls the case of Mill Pond Manor versus, is it Shaming Pond?
你好，我是翻译。你好，这是excuse me, who versus Shaming?
Shaming Pond
Shaming Fan and versus whom?
was the defendant in the case.
Thank you.
So it's Mill Pond versus Fan.
No Pond versus Fan。你好，这个案子是No Pond 树湾Shaming Pan 的案子。
Good afternoon, Your Honor. James Martone appearing on behalf of the plaintiff.
Good afternoon, Your Honor. Min Kim on behalf of the fan.
Good. Did you get that all, Madam Interpreter?
Yes, it's the attorney for the plaintiff and the defendant. 好，这是原告的律师还有被告的律师。
What are we doing on this case? Hold on, folks. I've got an interpreter. It's going to be one at a time. Let her interpret. Make sure she's heard, and then you can proceed. So, Madam Interpreter, could you translate what are we doing on this case today?
那我们今天这个案子要做什么？
Your Honor, this was the adjourned date from our prior pretrial conference. The defendant in the matter had made an oral motion to dismiss the case.
Go ahead, Madam Interpreter.
对，这个是上一次那个听证会前的一个休庭之后，这个被告他要求就是把这个案子撤销，口头上要求。
At last hearings, Your Honor, you had asked defendant brief response to an argument I made about the CARES Act, about plaintiff's complaint and notice complying with the CARES Act. Therefore, the motion should be denied.
上一次就问这个被告的反应，就是对可能对这种指控什么的反应，然后这个被告的这要求撤销案子的要求被拒绝了。
It appears, Your Honor, that defendants did submit the briefing last week, and we're here to address that matter now.
上个星期就是被告他就是没有那种参加听证会吧，然后现在我们就是来解决这个案子。
Ms. Kim.
Yes, Your Honor. As plaintiff's counsel stated, the brief was submitted last Friday as the court requested. I believe that we have not received any kind of response. We rely on what's been written to the court, unless the court has certain questions.
就是我们就是根据法庭的要求，就是被告的这个委员会已经提交了，就在上个星期五的时候已经提交了，根据法庭要求，但我们现在还没有收到回复，这个法庭肯定有问题要问。
I'm sorry. Is correct. We have not filed a reply to this. It wasn't our motion, Your Honor. I did not receive a copy of this by electronic fashion. I received it first via mail, which didn't arrive to my office till late on Wednesday night. So I haven't had a chance to reply, but I'm prepared to address or discuss some of the topics raised in the response, Your Honor.
对，就是我们就是没有收到这个文件吧，就是在星期三晚上就是在收到邮件，所以我们还没有可能没来得及回复，就我们要讨论这个话题。
I'm not sure why a electronic copy wasn't provided. Won't get into that. I would like a written response to the motion, however. How long will that take you? Hold on.
对，我不知道为什么没有提供这个电子版本的，就是我想要你提供一个书面的回复，你需要多长时间？
2 weeks be okay, Your Honor?
And it to, or plaintiff to file a response.
就是被告要提交回复。
They're to do that by February 14th.
在2月14号之前。
They'll set a hearing on the motion for February 18th, 2025 at 9 a.m.
这个听证会在2025年2月18号早上9点。
Your Honor, I'd just like to request the electronic copy of the response, which was not requested of me, Your Honor, just to be clear.
Yeah, but it's pretty much these days occurs in this case, but go ahead.
Additionally, Your Honor, I wanted to report that Mr. Fan has made his December and January rent payments to plaintiff, and they have not been cashed, but we have asked that they cash it.
就是我要求这个书面的，就是电子版本的回复，就是我要报告，就是范先生他已经付了12月和1月的房租了，付给被告，但被告还没有把这个可能兑现这个支票，就要求被告把那个支票就是兑现出来。
To address those payments, there was, the court had entered an escrow order, so we have not cashed those payments. They are in our possession. If the court, with defendant's consent and with the court's permission, I can instruct my clients to cash the checks and reduce the outstanding balance.
是上个季度的，所以还没有把它兑换出来，所以。
You have the court's permission to cash the check without prejudice to your case.
Thank you, Your Honor.
One other issue, Your Honor. Oh.
Go ahead, Madam Interpreter.
法庭它允许你把这个支票兑现出来。
Mr. Fan had also made some auto payments for his August, September, October, and I believe November rents. They are sort of held in a suspension because plaintiff has not accepted the payments. He had underpaid by, I believe, approximately $20, and he submitted a supplemental check make up the difference. And we would also have asked plaintiff to cash that and accept the payments as well. Just wanted to alert the court. Also, should Mr. Fan pay his February rent to the court or should he pay it to plaintiff?
范先生他已经自动付款付了8月份、9月份、10月份，还有应该是11月份的房租都付了，但是他被那个暂停，他就没有原告他没有接受这个付款吧，就还没有接受，然后他可能少付了大概$20左右，然后被告又提供了那个补充的支票，然后要求这个原告他来把这支票就是兑现出来吧，把接受这些付款。然后这个2月份的房租是付给法庭呢，还是付给原告？
Any access to any payments by the defendant, plaintiff is authorized and should cash. His February rent payment should be paid to the court.
Thank you.
对，这个付给被告的，他应该被告能够收到的付款都应该接受，就您把它兑现出来。2月份的房租应该付给法庭。
Thank you.
Thank you, Your Honor.
Your Honor, one more thing.
All right.
I'm so sorry to interrupt, but.
All right, Matt, hold on a second. Madam Interpreter, thank you very much. We're
you're
all
very
set.
welcome. Welcome. Thank you for your service. Have a nice day. Bye.
You too. Yes, Amy.
We need the Mill Pond Manor's email address for further documentation for assistance. Could the attorney provide a good contact
For
for
the complex?
Complex, correct.
All right. Counsel, can you provide an email address for Hawk? He's receiving, okay.
He has an appointment.
Okay. So if you could provide contact information for your client to Hawk, it would be greatly appreciated. Probably the easiest way to do that is to give it to my staff and we'll send it direct for you. All right, thank you.
Your Honor.
Thank you, Amy. The court's gonna stand in recess.
All right. Maybe seated. Mr. Rogers was stopped and ultimately attempted to flee while placed in handcuffs. Mr. Rogers was located with 24.2 grams of meth and $5,030 in U.S. currency.
Mr. Brown, was that Forsyth Street?
My apologies, Your Honor, mispronounced Forsyth.
Okay.
Also, Mr. Brown, did all the factual basis that you just gave this court, I just think I made a word up, did all happen in Fulton County?
Yes, sir.
All right.
Okay. All right. Mr. Adams?
Yes, Your Honor.
State your name, ma'am.
Parents, Ms. Gonzalez, parents are present in the courtroom with me. You're before the court today for your first appearance. You've been you've been waived up to adult court. You're not asking for the public defender, so we're not going to appoint him today. You've been charged with one count of attempted burglary of an occupied dwelling while armed. That's a first degree felony, punishable to 30 years in the Florida Department of Corrections. Judge Mallory has already found there's probable cause for your arrest. Ma'am, where do you live?
1701 Hamilton Avenue.
How long you Bay County?
How long have you lived in Bay County?
My whole life.
How long?
My whole life.
Okay. And are you going to school or working?
No, sir.
All right. Is there a prior record on Ms. Gonzalez?
Other than this charge, there's a less than 20, and that's it.
All right, I'm going to set a $10,000 bond. You're to have no contact with any of the co-defendants. Your next court date is March 10th at 9 o'clock.
Let's step to your right to the T. Wait, step on the T. Give us 1 second. Ready, sir? Face the TV, state your name.
Nicholas Barnes.
All right. Mr. Barnes, you're before the court today for your first appearance.
Yes, sir.
Appoint the Office of Public Defender to represent you. You've been charged by way of an information with attempted burglary of an occupied dwelling while armed. That's a first degree felony, punishable to 30 years in the Florida Department of Corrections. State attorney's already charged that by way of an information. You've been charged as an adult. Mr. Barnes, where do you live?
In Fountain, Florida, sir.
How long have you lived in Bay County?
All my life.
Is there a prior record, Mr. Barnes?
There was a juvenile armed burglary and robbery with a firearm.
All right, I'm going to set a $75,000 bond. You'll be able to contact family and friends in order to make your bond. You're to have absolutely no contact with any co-defendants in the case. Your next court date's March 10th at 9 o'clock.
Yes, sir.
Step to your right to the T. Can you sign? Or you want me to sign it for you?
You sign for?
Yes, I will, and I'll bring it to you. Can you step out? Next.
All right. Sir, state your name.
Javon Smith.
Mr. Smith, here before the court date for the first appearance, you have the courtroom. Your mother and your aunts present in the courtroom. You've been arrested on outstanding cases. The state has charged you as an adult with attempted burglary of an occupied dwelling and aggravated assault with a deadly weapon. The attempted burglary of a occupied dwelling that's while armed is a first-degree felony, punished with 30 years in the Florida Department of Corrections, and the aggravated assault with a deadly weapon is a third-degree felony, punished with 5 years in the Florida Department of Corrections and a $5,000 fine. Sir, where do you live?
Panama City.
How long have you lived in Panama City?
Well, I just came down here. I came from Georgia, but I've been down here like a couple months.
Okay. And is there a prior record on Mr. Smith?
You have a FTA times 7 from 19 to 22, VOP times 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Grand theft auto in 22. You have a robbery with a firearm in 24, armed battery, ag battery with a weapon 19, armed burglary 19, battery 20. His history goes back into 2018.
All right, sir. Based on your prior record and the nature of the charges, I'm gonna set a $75,000 bond on the attempted burglary of an occupied dwelling while armed, and $5,000 on the aggravated assault with a deadly weapon. You're to have no contact with the alleged victims in the case. You're also to have no contact with any of the co-defendants in the case. Your next court date's March 10th at 9 o'clock. Good luck.
Can you sign, or you need us to sign it for you? When the green light comes on, sign. Give us just a minute.
Yes, ma'am.
State your name, sir.
Jason Croft.
Mr. Croft, you're before the court today for your first appearance. You've been arrested on outstanding cases. The state has charged you as an adult with attempted burglary of an occupied dwelling while armed. That's a first-degree felony, punished with up to 30 years in the Florida Department of Corrections. Mr. Croft, where do you live?
12815 Croft Road, or 12815 Croft Road.
How long have you lived in?
My client.
Okay, all right. And how long have you lived in Bay County?
My whole life.
And are you working or going to school?
Yes, sir. I work with my dad. It's like part-time for his construction business.
Is there a prior record on Mr. Croft?
You have a petty theft in 23, it's juvenile, and delivery of synthetics in 22.
All right, Ms. Bennett, anything on behalf of the client?
Yes, actually, Mr. Croft has been in really good contact. Ms. Overstreet had informed me prior to waiving Mr. Croft up that would happen. I've talked to Mr. Croft and advised him of it. He didn't run. He actually turned himself in. He and his family have called yesterday and the day before yesterday to confirm that he would turn himself in. He spent 21 days in juvenile and then was released to house arrest on an ankle monitor. There were no violations of that. As he had stated, he works, and the money that he earns, he has to pay me according to his parents. He also participates in church. He lives with his parents. And Ms. Overstreet told me he's been waived up to keep him as a group, but he's been cooperative from the get-go with law enforcement and has been polite and worked with them. And so in light of that, I think he's shown that he is doing anything he can to be helping his case and to be doing what he's supposed to be doing. So we would ask for the pretrial release program, maybe in conjunction with a low bond.
Based on the nature of the charge, I'm gonna set a $75,000 bond. This is a serious charge. He's to have no contact with any of the co-defendants. Your next court date's March 10th at 9 o'clock.
Yes, sir. Step to your right to the T.
That's all
Are
I
you able to
have,
sign from the side?
excused.
All right, step
Ma'am?
out. I'll sign it for you.
That's all I have, may I be excused?
Yes, ma'am. Have a good weekend.
Thank you, you too.
Spanish is next.
We have the interpreter.
Hello, Your Honor.
Sir, if you'll raise your right hand, do you solemnly swear or affirm that you'll translate from Spanish to English to Spanish to the best of your ability?
Yes, Your Honor.
That's a 30 year. Yes, they're in the drawer. Thank you. All right, come here. All right, come here. Oh. State your name.
Alexander.
Ramírez Vázquez. Mr. Vasquez, you're before the court today for your first appearance.
Señor Vázquez, usted está frente de la corte hoy para su primera comparecencia.
You've been charged with one count of driving under the influence. That's a traffic misdemeanor, punishment to 6 months in the county jail and a $500 fine, and one count of no valid driver's license, which is a traffic misdemeanor, punishment to 60 days in the county jail.
Usted está siendo acusado de manejar bajo la influencia del alcohol. Eso es un delito menor. Pudieran darle 6 meses en la cárcel con $500 de multa, y también manejando sin licencia válida de conducir. Eso pudieran darle una condena de 60 días en la cárcel.
I've reviewed the Florida DUI uniform traffic citation as well as the Florida uniform traffic citation and find there's probable cause for your arrest.
He revisado la citación de tránsito uniforme del estado de Florida para los que manejan bajo los efectos del alcohol, y sí veo que hay causa razonable por su arresto.
Sir, where do you live?
Señora, ¿dónde vive?
Aquí en Florida.
Here in Florida.
How long have you lived in Florida?
¿Cuánto tiempo ha vivido en Florida?
4 años.
4 years.
Your prior record on Mr. Vasquez?
Locally, there's no valid ×3 last year and a leaving the scene. Texas, you have alien 16, 17, 19, resisting 16, marijuana 14, disorderly 10.
All right, I'm gonna set a $1,000 bond on the DUI and $500 on the no valid driver's license.
Entonces voy a poner una fianza de $1,000 para la acusación de manejar bajo la influencia del alcohol y $500 por no manejar con una licencia válida de conducir.
As a special condition of your bond, you'll submit to random breathalyzers as directed by the court. You shall not possess or consume any alcoholic beverages while on release.
Y por orden de la corte van a poder hacerte exámenes al azar de sople de alcohol, y también no puede ni poseer ni consumir alcohol después de que esté en libertad.
Your next court date's February 3rd at 1 o'clock. Good luck.
Y su próxima audiencia judicial es el 3 de febrero a la 1 de la tarde. Buena suerte.
That's all for Spanish.
Okay, thank you, sir. You,
Thank you, Your Honor.
have a good weekend.
You too, Your Honor.
Step on the X, sir. State your name.
Was David there, Watkins, fourth.
Mr. Wiggins, you're before the court today for your first appearance. You've been arrested on an outstanding capious for failure to appear for arraignment. Judge Judge Dyer has ordered you to be held on a $2,500 bond. I'm gonna leave that as it is. Your next court date is February 3rd at 1 o'clock. Good luck.
All right, sir, step to your right to the T. When the green light comes on, sign. Red X, sir. State your name.
Mr. Williams, you're before the court today for your first appearance. You've been arrested on outstanding warrant alleged, or two outstanding warrants alleging that you violated the terms and conditions of your probation. Judge Stevens has ordered you to be held without bond. I'm gonna leave that as it is. Your next court date's February 27th at 9 o'clock. Good luck.
Step behind him at the signature pad. Next. Red X, sir. State your name.
Stanley Hawk.
Mr. Hawk, you're before the court today for your first appearance. I'm going to appoint the Office of Public Defender. You've been arrested on an outstanding warrant alleged you violated the terms and conditions of your probation. Judge Rester has ordered to be held without bond. Your next court date is March 12th, 9 o'clock. Good luck.
Step behind him at the signature pad. Next. Guess we gotta get them. They're coming. Oh, I got plenty. When the green light comes on, you'll sign. Next, come on in. Red X, sir, state your name.
Dennis Moon.
Mr. Moon, you're before the court today for your first appearance. You've been arrested on an outstanding warrant out of Calhoun County. Judge Grover has set a $432 bond. I'm gonna leave that bond as it is. I'm gonna have a return date. February 11th. Sir?
I've been here for 45 days. Anybody get that rank current?
No, sir.
Different county.
All right, we have a return date of February 11th. Good luck.
February 11th.
Step on the T. When the green light comes on, sign, sir. Next. Braswell. Braswell. Ready? State your name.
Stephanie Braswell.
Ms. Braswell, you're before the court for your first appearance. I'm going to appoint the Office of Public Defender. You've been arrested for one count of possession of crack cocaine. That's a third-degree felony. Punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. In possession of drug paraphernalia, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. What about the fugitive warrant? Have we taken care of that, or are they going to do that later?
No, she has to finish her locals first. All of them came in together.
Okay. All right, ma'am. Where do you live at, Ms. Braswell?
I'm sorry?
Where do you live?
I'm Panama City.
How long have you lived in Bay County?
2.5, 3 years.
Are you working?
Not currently.
What's the prior record on Ms. Braswell?
Her record's out of Missouri, 24 marijuana times 3, paraphernalia, theft, 18 and 20, theft, shoplifting, 18, 19, 20, VOPs, 20.
I'm gonna set a $5,000 bond on the possession of cocaine, $1,000 on the possession of paraphernalia. She'll submit to random UAs as directed by the court. Her next court date is March 13th at 9 o'clock.
Step to your right to the T.
Okay, I'm sorry. Alright, so.
He gave you a $6,000 bond, but you can't get out even if you bond it out because you got a hold on you. And where the light is.
Okay, what about
Nothing. You can't do anything with it till you finish locals. Face the TV. State your name. Say your name.
My name's Valerie Mears.
Ms. Mears, you're before the court today for your first appearance. I am going to appoint the Office of Public Defender to represent you. You've been charged with 1 count of possession of marijuana, less than 20 grams. which is a first-degree misdemeanor, punishable with 1 year in the county jail and $1,000 fine. Possession of drug paraphernalia with a first-degree misdemeanor, punishable with 1 year in the county jail and $1,000 fine. And driving under the influence, which is a traffic misdemeanor. If it's your first offense, it's punishable with 6 months in the county jail. I reviewed the probable cause affidavits. I find there's probable cause for your arrest. Ma'am, where do you live?
Her, my address is 1071 Rosemont Street. I'll travel back and forth from home to here because my old man was working here.
All right, is there a prior record on Ms. Mears?
Sir.
20 introduction of contraband controlled substance, VOP 19 and 20, L and L 18. Please talk to me.
Recommend pre-trial get out of jail, have to put up bond. There's standard conditions you'll have to abide by. The special conditions, you'll submit random urinalysis and breathalyzers as directed by the court of the pretrial release program. You shall not possess or consume any alcoholic beverages while on release. Your next court date is February 3rd at 1 o'clock.
Step to your right to the T. Yes, but step to your right to the T. When the green light comes on, sign. Next. Wait for the light. Come on in. Step on the X. Face the TV. State your name.
Ms. McNeil, you're before the court date for your first appearance. You're not asking for the public defender. You've been charged with 1 count of burglary of a dwelling. That's a second-degree felony, punishable with 15 years in the Florida Department of Corrections and a $10,000 fine. I reviewed the probable cause affidavit. I'll find there's probable cause for your arrest. Ma'am, where do you live?
329 Lorena Place. My mother.
I can't. Where do you live? I'm sorry.
With my mother, 329 Lorena Place.
How long have you lived in Bay County?
All my life.
And are you working?
Am I working? Yeah, King Condos.
Okay, is there a prior record on this?
Had tampering with theft of utilities, 18 at DWLSR with the FTA on that.
I'm gonna set a $10,000 bond. Your next court date's March 10th at 9 o'clock.
Step to your right to the T. When the green light comes on, sign. Next. Red X, ma'am. State your name.
All right. Where do you, this is Samantha Williams. I'll appoint the Office of Public Defender to represent you. Ma'am, where do you live?
3325 West 23rd Street, Panama City, Florida.
How long have you lived in Bay County?
My whole life.
All right, and you're charged with 1 count of burglary of a conveyance. That's a third-degree felony, punishable with 5 years in the Florida Department of Corrections and a $5,000 fine, and domestic violence battery, which is a first-degree misdemeanor, punishable with 1 year in the county jail and a $1,000 fine. I reviewed the probable cause affidavit. I'll find there's probable cause for your arrest. Ma'am, where do you live?
Where do you live?
Panama City.
How long have you lived in Bay County?
My whole life.
Are you working?
I don't have a job right now.
All right, and is there a prior record on Ms. Williams?
Got her on felony probation for battery on a firefighter EMT.
What's that case number?
24-1155 CF.
I don't know why they did this as a burglary of a conveyance. That's what they got it charged as. Oh, they didn't matter.
Should I tell them?
What I'm gonna do is I'm gonna set a $10,000 on the burglary, $1,000 on the battery. She's to have no contact with the alleged victim in the case. I'm going to issue a warrant for alleged she violated probation on basis charges are new next February 10th at 9 o'clock. Good luck.
Step to your right to the T. When the green light comes on, sign. Next. Next. Red X ma'am, state your, face the TV, state your name.
Renee Perry.
Mr. Perry, you're before the court today for your first appearance. I'll appoint the Office of Public Defender to represent you. You've been charged with one count of petty theft, second or subsequent offense. That's a third-degree felony, punishable up to 5 years, Florida Department of Corrections, and a $5,000 fine. Smuggling contraband into a detention facility, that's a third-degree felony, punishable with 5 years in Florida Corrections, $5 fine. Possession of two possessions of a controlled substance, that's both the third felony, 5 years in Florida Department of Corrections, and a $5,000 fine. And possession of drug paraphernalia, which is a first-degree misdemeanor, punishable with 1 year in the county jail and a $1,000 fine. I've reviewed the probable cause affidavit. I'll find there's probable cause for your arrest. Ma'am, where do you live?
Panama City Beach.
How long have you lived in Macon?
About 10 years.
Are you working?
Yes.
Where do you work?
For 38 Black Car Service.
Where?
38 Black Car Service. It's this taxi shuttle service.
Is there a prior record on Miss Perry?
She had a fraudulent and illegal use of credit cards in 23 and a no valid in 19. That's all she's showing.
How was this mess?
I'm gonna recommend to the pretrial release program. That'll get her out of jail whenever to put up a
And Dorothy Williams.
Good afternoon, Your Honor. Sydney Fontanella, P86316 for the plaintiff.
Boy. State your name, ma'am.
My name is Artelia Reed, Judge Simpson.
Yes, ma'am. All right. Okay, where are we on this case?
Your Honor, if I may,
Yes.
Ms. Reeves, I believe, spoke with Ms. Dornbush from my office yesterday. Unfortunately, there has not been a resolution on this case right now. We have been in communication with our client to see if there is a way for us to solve this. Unfortunately, we haven't heard anything back. So right now we are requesting that this be set for a bench trial because I don't think we're going to be able to, we haven't been able to resolve it. Yeah.
Yes, ma'am.
I feel like I'm in a twilight zone. I'm just going round and around and I'm at.
Okay, that's my everyday. So go ahead. What?
I feel like I'm in the twilight zone.
Why?
I talked to Attorney Rachel yesterday.
Yes, Ms. Dornbush.
And she's saying, okay, that she works for Arbor Woods and Arbor Woods is paying her to collect some money out of me. And I'm telling her that I paid it. I paid it. I bought all types of proof. Somebody wiped my name out up there in that office, but I did tell Attorney General, not Attorney General, Attorney Rachel yesterday that I will call MoneyGram again.
Okay.
And see if I can, if I get in contact with the fraud department, see if they can replace this. Because I paid and now I got to prove that I paid. And
okay, I understand. So here's what I'm going to do. I'm going to set it for trial. I'm going to set it for February 18th. So that gives you some time to do that. You're going to pay your February rent to the landlord. I just ask.
Yes, sir.
I know
I'm
that you
going
will.
to pay
All right.
February rent. You know what, Joe Simpson?
Yeah.
I just rather look at you on TV. I don't want to be looking at you every week, every month. Oh my goodness.
Why, I look better on TV?
Yeah.
Yes?
Yeah, I'm on TV.
Wow.
Yeah.
That kind of hurts, doesn't it?
So come back on the 18th?
Yeah.
At
It'd
what
be-
time?
It'd be at 9 a.m. It'd be for a trial, but it'll give you time to get the information. What we're hoping is you can get that information from them.
Mhm.
And then if it can't be resolved, then I'll hear testimony and I'll resolve it.
Okay. Okay, sir.
Fair enough? So you gotta
Yes.
come back